are magistrate tribal. Now,
Lordship,
my lord, here, my lord, what has happened is that, my lord, there are three title suits, my lord, pending by and between the parties. My lord, the de facto complainant and this petitioner. Now, my
Yes.
lord, this FIR was registered on 3rd of June 2023. Now, my lord, prior to that, there is a title suit number 95 of 2022, which is a suit for declaration, partition, and possession. Now, my lord, thereafter, there is a title suit number 16 of 23. Lordship would get the plaint of the first title suit at page 23 of
Yes,
my
yes,
application.
yes, CD not received, my lord.
Okay, CD is not there.
But
Oh,
You have to wait for. They have request statement. All the CD has written. So
acha.
that's why the matter cannot be taken up today. So 1 day or 2 days?
yes, 1 day, my lord.
Tomorrow.
Tomorrow, my lord.
Okay, come on
Tomorrow.
then.
Tomorrow. Grateful. Grateful.
Not today.
CD call for.
Lordship, in item number 2, I am appearing on behalf of the appellant petitioner. My lord, this case is being conducted by senior counsel, Mr. Devashish Kaur, as because he is on the way. Would be grateful if my lord kindly give a short passover for this matter.
Not Passover, come on tomorrow.
Not
Not today.
In 3, I appear for the petitioner.
Yes.
My lord, the allegations are, my lord, 406 and 420 essentially. Now, my lord, the complaint states that on 22nd of January 24, one Joseph Khati promised the complainant to get certain jobs in Canada, and in lieu of that, he had paid him 29 lakhs 90,000 rupees. This is, my lord, the crux of the complaint, after which he says that Joseph Khati misappropriated that money. Now, my lord, I am not Joseph Khati, I am his brother, Oshit Khati. Now, my lord, my involvement in this entire alleged offense, my lord, will find from the 9th line of the complaint at page 9, my lord. Page 9 of the petition, my lord, 9th line from the top. The line starts with after that guarantors.
Yes.
My lord, may I read out, my lord?
Yes, read out.
My lord, it says that after that, guarantors, namely Subha Khati, wife of Joseph Khati, who is the principal accused, resident of road number 1, Pragati Colony, Bhuttabadi, Post Office and Police Station, Bagdogra, District Darjeeling, State of West Bengal, etc. Oshit Khati, son of late Kiran Khati, who is the brother of Joseph Khati, resident of Bhuttabadi, Bagdogra, and Rikash Pradhan, son of Sudan Pradhan, resident of Shantigram, Nipronia, Bosti, Nakshalbadi, asked me to give the entire money to Joseph Khati. And on such promise, I gave the entire money to Joseph Khati. So, my lord, my involvement is only to the extent that I had told the complainant to give the money to Joseph Khati. Now, my lord, after that, there is a civil angle to this. Kindly reads thereafter, my lord. When I asked Joseph Khati about the reason for unnecessary delay in paperwork of visa, and also whenever I am requesting him to refund my money, one legal notice has placed before me dated 18/10/2024, sent by his partner Ravi Tejas, stating that he will clear all payment within December 21st, 2024, and also issued a post-dated check of rupees 23 lakhs 95,000 as security, but till today he has not deposited a single amount of money which was due. So, my lord, this also does not state that whether these checks that were issued, they had bounced, they got dishonored or not. And, my lord, there is also a considerable delay in filing of this complaint because the incident dates back to the month of January 24, and the complaint, my lord, was registered on 31st of May 2025, after 1.5 years. So, my lord, there is considerable delay. My involvement is only to the extent of telling that man to give the money. And after that, my lord, the partner of the principal accused has also issued post-dated checks to him, promising him as a security. What happened to those checks? The complaint is completely silent. I am of the instruction that only because the time period of these checks had, my lord, expired, which is why after a lapse of 7 months from the date of issuance of those checks, they have filed this criminal complaint. So, my lord, I am praying for bail on any condition. My custodial interrogation is not necessary. I am Oshit Khati, my lord, brother of Joseph Khati.
Okay. Yes,
Yeah, my lord. Well, Mr. Mishra's matter, he's not present today. so
very well. You
on
proceed,
this
no
matter.
issue.
My lord, the section 35 notices were not received by them. They're not cooperating. They're praying for anticipatory bail and they're not cooperating with the investigation at the initial stage, my lord. A huge amount is involved, my lord.
My lord, I do not have
They have
any such
come
instructions, my
forth
lord,
with
Let me
because
finish first.
They have
Yes,
come
yes.
before this court for an anticipatory bail, my lord. But the basic thing is that they could have appeared and they have presented their case. They have made their submissions before the IO. What is the harm, my lord?
Yes,
It is a now
But
under
if-
new act, it is their statutory duty to comply with the notice
yes,
under section 35, my lord. That has not
So-
been. Therefore,
certainly so, my lord.
that's not their fault.
I have no intention to play with
amount
the
is
investigating
involved.
authority. My lord, grants me an opportunity. If there is a 35 notice on record, grants me an opportunity, I'll go, my lord, comply with the notice and come back before your lordship. Kindly keeps it any day next week, my lord, I'll meet the IO.
let's see. Okay, please take down. On the prayer of the learned counsel appearing on behalf of the petitioner, the matter be adjourned today. Matter be adjourned today. Let the matter appear in the list in the next week. Full stop. The petitioner may approach the investigating agency in his response to the notice under section 35 within bracket 3 BNSS. In the meantime,
I'm deeply.
next.
But let there be a report from the IO about the
Okay.
complaint.
I have to submit a report on that. I have to submit a report on the urgent date.
Seizure.
Next,
My lord, in 4 I appear for the petitioner.
Tomorrow, case diary is required.
CD is not there.
My lord, can it be taken up day after, my lord?
Okay, day after tomorrow. Next,
Lordship, I am for the petition.
I am for the state.
The allegation is under section 182 and 74 of BNS. Lordship, petitioners are the brother-in-laws of the complainant. And there is delay of 44 days lodging the FIR. And the dispute is regarding a family dispute. And after thought, Lordship, it is very clear from the FIR itself that they have waited for some settlement or something like that. And whatever happens, that was totally a family dispute, and there is counter case also, Lordship. Page number 12, the FIR, and page number 13, the counter FIR, Lordship. Actually, the complainant has, Lordship, they are under protection by the order of the coordinate bench.
Lordship, on the last occasion, the matter was heard at length
Yes,
before the Honorable Justice Tirthankar Ghosh, the coordinate bench. And the Honorable Justice was pleased to provide the petitioner interim protection with a direction that the statement of the victim to be recorded. Because the injury sustained by the victim is as the patella, that is a knee injury. And obviously the injury report reveals that it's grievous. But it is also admitted fact that after 44 days, the FIR was lodged. Now the statement of the victim has been recorded in page 58. Here, Lordship, there are two petitioners. One is Bhagatosh Adhikari and another is Anitosh Adhikari.
who
Petitioner
are
of
they?
brothers.
They are the brothers.
Mm.
And de facto complainant is the wife,
Wife of the victim.
Wife of the
one of the petitioner number one.
But the victim is the brother, Ranatosh Adhikari.
Ranatosh Adhikari is the
Three
victim.
brothers are there. Bhagatosh Adhikari, Anitosh Adhikari are the accused persons, and Ranatosh is the victim.
Ranatosh is the victim, younger brother of the petitioners.
Yes. And now, Lordship, so far the statement clearly reveals that there is no such allegation against Bhagatosh Adhikari. There is an allegation of fist and blows, but there is the allegation of inflicting major injuries against Anitosh Adhikari. That is petitioner number 2. Lordship, page 50 is the injury report and page 58 is the statement of the victim Ranatosh, which has been recorded by the IO after the direction passed by the Honorable Coordinate Bench. Ranatosh is the victim.
Lordship, the actual fact is that the victim received the injury by falling on the ground. That's why there is a afterthought.
Let's see,
afterthought
let's
of
see, okay, okay.
34 days they have lodged the complaint.
The state also is admitting that the complaint lodged over 44 days.
Where is the injury report?
Page 50, Lordship,
50.
50.
Grievous injury. So two brother assaulted one brother.
One brother.
This is the issue.
Family feud.
Very. Please take down. In pursuance to the direction of this court, while order dated June 19, 2025, the investigating agency has submitted the injury report, including the statement of
Of the victim.
the victim. Next, learned counsel appearing on behalf of the petitioner submits that the dispute between the families cropped up to injury to the injured. The family disputes may be minimized, but for the purpose of investigation, the custodial interrogation of the petitioner is not. Petitioners are not necessary. Learned PP place the city.
Learned state advocate.
Learned state advocate place the city and submits that there are family disputes. Admittedly, there are family disputes. Injury sustained by the injured is grievous in nature. He objected to the bail prayer of the petitioners. Having heard the learned counsel for the petitioner and also considering the injury report, which reflected the injury sustained by the injured is grievous in nature, it appears to me that it appears from the fact of the FIR that two brothers alleged to have been committed assault upon one younger brother. Full stop. Wife of one of the petitioner is the de facto complainant.
No.
Yes, Tumpa Roy Adhikari is the wife of Bhavatos Adhikari.
Wife of Bhavatos. Dipti Adhikari is the complainant.
Lordship, at page 2.
Who is the complainant?
Dipti Adhikari.
Deepti Adhikari.
Wife of the victim.
Wife of the victim. No, the wife of the victim is the de facto complainant. Full stop. Considering the entire aspect, it appears to me that the dispute between the parties cropped up the entire issue and injury sustained by the injured, though grievous in nature, but that might happen due to the sudden quarrel between the parties. And the circumstances shows that the investigation has proceeded much. Injury report has been collected. Statement of the victim has been recorded. Considering the issue, I intend to grant the bail in favor of the petitioners.
Anticipatory bail.
Anticipatory bail in favor of the petitioners. In the event of arrest, 10,000 with 2 registered security each, subject to satisfaction of
One must be local.
PS,
Magistrate
CGM, Jalpaiguri.
Yes. Lordship, one must be local, Lordship.
CGM, Jalpaiguri. CGL Jalpaiguri. On condition that the
As charge sheet is pending, meet the IO at least once in fortnight.
once in a week,
Once in a, very good.
the petitioners must appear before the IO once in a week and shall comply with the other provisions laid down for 38(2) CRPC.
Much obliged.
Disposed of. Next,
Worship, I am appearing for the.
Lordship, CD is not available, Lordship. Item number 6. One
day
day.
after tomorrow,
Grateful.
Lordship, item number 7 and 8 also, Lordship.
call the matters first. Yes,
Yeah.
day after tomorrow,
No, Lordship, I am paying for this week.
not this week. Very well, call the city. Next week, the city will be there. Not this week. Next,
Lordship, 8 also, Lordship.
no city is there. Day after tomorrow. Yes, next.
Lordship, 9 also, Lordship.
No
Day after tomorrow, no.
Lordship, it could be scheduled tomorrow.
schedule day after tomorrow is not good for you.
Day after tomorrow.
Day after tomorrow.
Much obliged.
Not this week. Very well, not this week.
Lordship, CD not produced, one day, Lordship.
Not this week.
Grateful, Lordship.
Next Monday.
Lordship, I am for the commission.
Yes.
CD not received, my lord.
City not received. Very well.
Earlier occasion also, Lordship, one order passed by the honorable court that CD was incomplete. That's why CD again called for. Can we make it the day after tomorrow?
Day after tomorrow.
Some pages was misplaced from the CD. That also mentioned in the order sheet also.
Give me the order.
Explanations, give a direction to explanation, Worships. I have just received the CD and found that some pages are missing. I have already communicated to Lordships. And I think his personal appearance along with the CD is necessary.
No, there is no direction of personal appearance like that.
But now I'm playing, my lord, as because
Why you are
already
paying?
today I'm playing.
Today, why are you paying that?
CD not
Is there
received.
CD?
No.
Let the CD be appear. If there is anything, you have informed that,
Yes,
but you have not called for personal appearance or like.
No.
Then
Submit a report. The next date when. the-
investigation of case will submit the report.
Yes, ma'am.
So report is required.
No, nothing. Even CD also not sent. That's why.
Okay, you want an order.
Yeah, order, my lord, so
Let's
that
take
will
down. Okay.
appear personal. along
Learned
with the
counsel appearing on behalf of the state submits that the order dated June 19, 2025, the coordinate bench of this court has directed the investigating officer to submit a report regarding missing pages of original CD. Full stop. No report is placed. Learned counsel appearing for the state prayed for an appropriate order. Having heard the learned counsel for the parties, it appears that the report as called for by the state has not been placed by the investigating officer. Accordingly, investigating officer of this case, PS,
Shitai, my lord. Shitai piece.
investigating officer concern of Sita PS is directed to appear before this court day after tomorrow. Appear before this court personally day after tomorrow with the CD, with the complete CD,
Obliged.
with a complete CD, and a report wherein he must mention why the pages of the CD are missing, were missing when it was placed before this court on June 19, 2025.
Obliged to know.
Kindly next.
Equal for the petition. Lordship, NDPS matter,
NDPS.
NDPS, anticipatory bail.
Okay,
Can you see page 9? That is the letter of complaint,
page 9.
where 4 persons were apprehended and from whom the contraband articles were seized. The petitioner is not one of those 4. My name is not there in the first inventory.
What is your name?
My name is Lordship Uttam Bormon.
Uttam Bormon.
Lordship.
Sanju, Komol, Jitendra, and Raul. Yes,
Lordship. Now page 16 is the Caesar list.
page 16.
16.
Yes,
Now names are there from whom the contraband articles were seized.
yes.
My name is not there.
Very good.
Now why I am before your lordship is that police is raiding my house and stating that regarding this case, I don't know what is my involvement because I am completely in dark regarding any activity or any involvement of my.
Police seized your house?
No lordship, police raided in my house.
Raided.
Raided.
Committed raid.
So apprehending arrest and because I don't have any knowledge, so why the police is raiding in connection with this case?
You must have apprehended something.
So
Otherwise you may
yes.
not have come.
Now, yes, I have apprehended the police may arrest me,
Yes.
but now my involvement, lordship, the state can show it from the case diary.
My lord, there are CDS called detail record of there was communication, there was between this the person arrested and this petitioner. My lord.
Private person, there are 4 persons arrested.
This
This thing has
person
been, whether anything recovered from Uttam,
No, nothing.
then why you were saying that?
He has not been arrested. He is absconding. Until and unless he is arrested, how can we recover anything from him?
Okay, whether his house raided?
His
Anything?
house has been, he is not in the house.
So why you can connect with the person with this offense?
As per the CDR, my lord.
As per the CDS?
CDR, my lord.
Okay.
Lordship knows that
I-
Vallavi Arimuthu's judgment, where 3 judges bench of Supreme Court said regarding all this CDR connection is a matter of trial. Vacuum statement, lordship, if any, I don't know.
Very well. I directed the authority to appear before the authority. Please take down. This is an application for anticipatory bail by the petitioner who apprehending arrest in connection with, what is the case number?
Lordship, Ghoksardanga Police Station case number 700 of 2025.
Out of
Ghoksardanga.
Roksadanga police station case number they can such and such under section such and such. Full stop. It is learned counsel for the petitioner submitted that he is not the charge seated accused persons. No, sorry, that's it. He is not the accused person. He is not the person named in the FIR or nothing has been seized from his custody. Only his house was raided by the police authority in connection with, by the police authority, by the investigating authority in connection with this case. Though nothing has been recovered from his house. He pled for bail in any connection. Learned counsel appearing on the state raised strong objection and submits that there are strong connection between the accused person, between the 4 accused person of this case with the present petition. There are serious reports, CDRs regarding the connection, prove the connection of the petitioners with the other accused persons. learned counsel for the state firmly submits that, learned counsel for the state, in his usual fairness submits that CD does not reflect anything recovery from the possession or house of the petitioner. Having heard the learned counsel for the petition, having heard the learned counsel for the parties, and considering the fact that no incriminating, no contraband article has been seized from the possession of the petitioner, though his house has been raided. Full stop. At this juncture, in my view, the custodial interrogation of the petitioner is not allowed. Thank you. Accordingly, the bail prayer, anticipated bail prayer of the petitioner is considered and allowed. Next para, in the event of arrest, the petitioner may find bail of rupees. In the event of arrest, the petitioner may find bail of rupees 10,000 with two registered securities. One must be local. One of whom must be local, subject to the satisfaction of
Lordship, in special court NDPS Coach Bihar.
special court NDPS Coach Bihar, with a condition that the petitioner must appear before the Ayog once in a week until further order, and shall comply with the provisions, comply with the conditions laid down under section 432 CRS.
Lordship, one intelligence, Lordship, the 700 of 2025, may I be permitted to correct this 2024
Okay, next part.
case number?
The
Yeah,
learned counsel on record for the petitioner is permitted to correct the. Yes, what is the number?
Lordship, Bokshadanga PS case, police station case number 700 of 2024, but it's mentioned wrongly, Lordship, 2025.
No, it is corrected. No, it was corrected.
Oh, in my copy, Lordship, yeah.
Okay, last part.
I will,
Corrected in our field, otherwise this serial does not.
my junior did not correct in my copy.
Yes.
Grateful, Lordship. Grateful.
Next,
Lordship, item number 13, I beg to appear on behalf of the petitioner.
I am appealing, my lord. I am appealing for the state.
Lordship, this is a case under section 489B and 489C of IPC regarding counterfeit currency. Lordship, one person named Krishna Rai and Pulki was arrested on 3/3/2022, and from his possession, 55 notes of 500 rupees denomination were found. Subsequently, charge sheet has been filed in this matter, Lordship, and the present petitioner has been implicated on the basis of a statement of the co-accused. Lordship, another co-accused standing on the same footing has already been granted bail by the Honorable High Court. It's at page 21, Lordship, P5, manager P5. Nothing has been recovered from the possession of the present petitioner, Lordship, standing on the same footing.
Only, my lord, the name was taken by the arrested person, the co-accused person.
standing on the same,
Standing.
please take down. Learned counsel for the petitioner submits that the that no recovery has been made in connection with the case where a huge quantity of what's recovered?
My lord,
Counterfeit currency.
27,500. 7,500.
27,500 counterfeit Indian currency note was recovered from the accused person. From the co-accused person. The name of the present petitioner is transferred from the statement of the co-accused person. He further submits that one of the co-accused person who was standing on the same footing was enlarged on bail by this court, filed order dated 7/6/2022 in connection with CRM within bracket A 263 of 2020.
No, 263.
263.
Huh.
263 বলেছে? 263 of 2022. He prayed for similar relief.
My only one objection, my lord, that was cases of 2022. We are in 2025. Still now he is absconding.
Lordship, there is no applicant.
Very good. Yes, heard. The learned counsel appearing on behalf of the state raised strong objects and submits that the present petitioner was absconded during the entire period. The case was started in the year 2022. Now we have, now the charge sheet has already been submitted. So at this juncture, the bail prayer, at this juncture, the bail prayer may not be allowed. Having heard the learned counsel for the petitioner, also considering the fact that the present petitioner is standing on the same footing that of the other co-accused person whose bail prayer was granted by this court in CRM within bracket A263 of 2020. On the same of the observation, the petitioner deserves anticipated. Petitioner namely such and such may find bail of rupees. Petitioner named such and such completed. May find bail of rupees 10,000 with 2 registered securities to the satisfaction of arresting.
Learned SCGM.
Charge sheet submitted.
Charge sheet submitted.
Charge sheet submitted.
SCG.
SG.
Learned SCGM.
Kashian.
SCGM Karsi. Already charges submitted. So subject to the condition laid down under section 438 within bracket 2 CRS. With further condition that he must appear before the court as and when the matters are applicable.
Good.
Much.
Next.
Item number 40.
14, I beg to appear on with the rest, defer the complaint.
Yes.
Lordship, this is case under section 406, 418, 420, 506 and 120 of PLP, 120 P of PLP. The allegation is that the father of the complainant has entered into an agreement to purchase top rooms from from the petitioners. And subsequently, they have paid rupees 33 lakhs in pursuance to that agreement, out of the total agreed sum of 35 lakhs. Subsequently, when they asked for the registration of these shop rooms, the present petitioners had asked for a sum of rupees 10 lakh rupees more. And subsequently, it was found that the land has, that the shop rooms have been sold to some other persons. Lordship, they have also filed a civil case with the same remedies and cause of action immediately 9 days after the initiation of the present case.
Yes.
And the WS has already been filed. I have appeared in that case.
Yes.
Lordship, this case is primarily a civil in nature, even if we go by the contents of the FIR, that there was an agreement and there is a breach of agreement. So this is essentially a civil nature matter, and the petitioner also and the complainant also acknowledge the same, and hence he has filed the civil suit. Kindly, Lordship, comes at page number 45. Lordship, this is the plaint of the present petitioner, present complainant. Huh?
What is the FIR?
Lordship, FIR is at, Lordship, FIR was lodged on the basis of an application under section 175(3), which is at page 20, Lordship.
Page
20,
20.
Lordship. The complaint is at page 20.
Yes.
Lordship,
Yes. Hard. Yes.
De facto complaint is here, my lord. I think there are some grievances here.
My lord, he has entered into an agreement with me for an amount of 35 lakhs, out of which 33 has already been paid to him. Thereafter, he has sold the shop room to someone else who are the
Without cancelling this.
Yes,
Lordship, if there is a single amount,
And
they
he
can
is
show
not-
they have paid us.
but
So
he is not
pension
complying.
cannot-
Let me finish, sir. He is not complying with the notices sent to him under section 35 of the BNSS. He's interrupting the investigation, madam.
Lordship,
He is not complying with that.
Let them finish, thereafter your chance would come.
Only let him secure that money. And he is not a local resident also. He is a resident of Bihar, Hakurganj.
Yes, what is the investigation?
Investigation, my lord, we have seized the original agreement as well as the deed, subsequent the deed, on the basis of which they have sold the property to some other persons. Now, and already handed over to them after seizing, we have the certified copies as well as the photocopies. That's a fact that now civil cases are pending. It doesn't mean that the criminal cases cannot be, my lord, investigation, because the remedies are different in both the matters. One remedy is punishment and one remedy is the amount which he has under the specific purpose.
Whether they are participating in the investigation.
Lordship,
No, they are
No.
not, they are absconding. That's
So
why.
kindly see the order impugn of the session judge, my lord.
Lordship,
Specifically, it has been mentioned there. On the internal page 4 of the said order. The second paragraph. He has further submitted that both the accused persons were served with the notice under section 35(3) of the BNSS, but none of the accused persons appeared to compliance of the said order.
Yes, what is your submission?
Firstly, Lordship, in compliance to the 35 notice, I went to the police station, but on the same date, the IU was not there. The CCTV footage can be asked from the prosecution.
That all bogus. Why you are not there? You have to comply the notice.
I was there, Lordship.
In all cases,
No, no.
the CCTV footages are called for.
The
There are
other
some,
two accused person also went there, but they have also given legal notice in that regard.
no.
And
That not
the
be.
entire 33 lakh amount rupees, they are saying that they have paid in cash. Lordship, can you?
He has signed the agreement. He has accepted it.
Lordship knows very well that an amount of more than 20,000 rupees cannot be paid through cash.
When the transaction was
This
made,
cannot be paid. through cash,
2021.
It cannot be received also in cash. So
yes.
when you have signed the agreement, that means.
So
you have-
let him secure the amount.
Lordship, this is a primarily civil in nature matter, Lordship. There is a breach of agreement, even if we consider.
If you want to secure the money, I can pass the interim.
Grateful, Lord.
Lordship, then can kindly give me a direction, kindly give password, keep it a password.
Come on tomorrow then.
No, Lord.
Not today.
Lordship, I am for the state. Lordship,
Yes.
case diary.
You are for the petitioner? Do you have the case diary? No case diary.
No case diary.
Day after tomorrow?
Promise to marry, Lordship. That's what the NS Act.
Whatever may be.
Yes, sir.
Place
Case
the
diary.
case diary. Day after tomorrow. Next.
Lord, I'm for the petition, I'm praying for one day accommodation.
I am for the respondent opposition.
Item number 16. Who is for the petitioner?
Lord, I'm for the petition, Lord, I'm asking for one day accommodation, Lord. Kindly, it's
One
on the
day
ground of
accommodation.
the illness of the hour.
In that case, kindly fix it Monday. I mean.
Next Monday.
Next week.
Come on, next
Any
Monday.
day.
My Lord.
Next Monday. Not today, not this week.
Lordship, I am for the state lordship. Series not available, lordship.
My Lordship, kindly fix it on Wednesday.
Day after tomorrow. Yeah. Come on, day after tomorrow.
Grateful, lordship.
18.
Not this week.
I am for the state CD recipient.
Petitioner is not there, not this week.
Obliged, Your Lordship.
Next.
19.
Not today.
20.
No case diary, Lordship.
Not this week.
21. I'm for the petition.
Registered যেটা ছিল
Lordship,
my junior had been to the office for collecting CD. Just pass over. If CD is available, I will ready.
Whether CD is available or not.
I'm sent by
Now 11:45 now, how are you sending this? Come on tomorrow.
tomorrow.
Not today.
22, I'm for the petitioners.
Yes.
Lordship, says the last order.
কাগজগুলো দিন।
May I place my case, Lordship?
Now let's see whether they are ready or not.
Registered my lord, in this case, my lord, a report call from through register, whether they had prefer any application, they prayed for a default bail, my lord.
Default bill.
Yes, my lord. But
No, Lordship,
their
it
default
is
bail
not
will be
there.
gone if they didn't file any bail application during that period. So earlier,
Lordship, perhaps the state is not aware of the earlier order. My case is that, my case is completely from what the state is making the submission. May I place my case, Lordship?
One order was passed. They had.
Yes, Lordship, order was first.
And what is your name?
Lordship, my name is Sapikul
Sapi,
Haq.
Sapikul Haq.
Haq.
এটাই তো registered
Yes.
But
What is
may-
your submission?
Yes, Lordship. Lordship, the petitioner kindly sees page 23. There's an order dated 4/9/2024.
Lordship, in this case, Lordship, CD not available today. I have sent, that's why my junior.
Lordship,
So I need a one-day accommodation, otherwise I can't assist the court properly, my lord.
What is this? Not CD?
No, this is a brief.
Lordship, may I make my submission online regarding this? I am praying bail on behalf of statutory ground. And what the court, to my little understanding, is that whether I am eligible to get bail under statutory point or not. Whatever there is in the case diary
No, no.
will not restrain. the
Yes,
court
yes,
from
that is
doing
not
it.
the issue.
So the case diary is not important here.
Whatever
I
will
have
come on
not,
tomorrow. Come on tomorrow.
I have filed the certified copies even.
Lordship,
It is
Yes,
the
I,
order-
report is also here.
Okay, report.
Okay. Let them
Lordship.
say. Otherwise it will be difficult.
Lordship,
Thereafter they will say, no, no, CD is not there.
Lordship,
Okay. So
grateful, Lordship.
next.
Item number 23.
The bill application, commercial quantity,
What passover?
Item number
23,
going on the code number 2, something on behalf of the applicant.
not commercial quantity, but they were arrested, 2 persons are there, Ranjit Haldat is petitioner and one Miss Mehboob, and from them 25.5 kilos of gaja has been recovered. Up to 20 kg, above them that is commercial quantity. Charge sheet has been filed, I don't know why bill application.
Charge sheet file.
Charge sheet filed. An investigation,
Where you will pass it over for a while.
Grateful, Lordship.
Passover.
24.
So I'm for the petition.
Could be more.
So this is a NDP matter and 23 cartons of cough syrup was recovered from him. The cartoon contains 100 bottles of cough syrup.
Yes.
These are about the item was in 30 September 2023. And the charge was framed on again April of 2024, but till that 2 witnesses were examined. On earlier occasion, there was a direction passed by the coordinate bench to expedite the trial.
What is the direction?
Or page 50, page 50, right?
Page-
46 and 47 and 48 page. Orders were having.
Page 50, my lord, of the petition. Order dated 12th of December 2024. Paragraph number 4.
20th of December.
20th of December 2024. Paragraph number 4.
Already direction is there for expeditious
Yes,
trial.
sir. Yes, ma'am.
What you made time frame.
Time frame? How can it be time frame? You know the burden of the special judges. Then
What's the charge has been placed on 2nd April 2024.
No, total
Already 1
witness,
year has been
total charge sheet
passed.
witness are 15, ma'am.
Out of 15, only 2 has been examined.
no. When you move the last application for bail on 20th December 2024.
After that, one order is there, my lord. That is of 19th of February 2025.
Again you have to. Already 5 times, 6 times.
Yes, Lord.
Only 6 times approach this court. But the trial is going on.
Trial is going.
Okay. Please take down.
2,300 bottles of cough syrup.
Huge quantity bottle of cough syrup. Huge quantity bottle of cough syrup was seized from the possession of the present petitioner in connection with this case, in connection with the NDPS case, pending before the learned special judge. The petitioner moved earlier 6 times before this court for bail. In all the occasions, the coordinate bench of this court, division benches of this court has rejected the prayer of bail. Again, the bail prayer was moved before this court on the ground that a time frame schedule, a schedule may be framed for disposal, for conclusion of the trial by the special judge. Having heard the merit of this matter and also considering the fact that on the earlier occasion, the bail prayer of the petitioner was considered and rejected by this court, I am not inclined to grant bail in favor of the petitioner as the trial is going on smoothly. I further observe that there is no objection on the side of the petitioner that the trial has been stalled before the special judge as full stop, as well perceived from the facts of situations thereon, that the special judges are burdened with several special cases. Thus, the trial cannot be concluded in time-bound manner. However, I direct the learned special judge to conclude the trial of the matter of the case as early as possible, most preferably within 1 year.
Yes.
Most preferably within 1 year from date. Full stop. Under the above jurisdiction, the CRM NDPS 257 of 2025 is rejected. Rejected and disposed of.
Grateful.
Next,
I am appealing for the statement.
My lord, this matter is related to the NDPS for appreciation of my application for bail. First, I would like to draw your kind attention to the written complaint. That is the running page number 12 and 13. More specifically, I am submitting, my lord. Page number 13 is very much important for consideration my application for bail. From the page number 30, running paragraph number 3,
yes,
the search and seizure was done from 1:15 hours to 1:45 hours. That is after sunset. But nowhere in the written complaint reflects about the reason to believe, particular the fact, what prompted him to done the search and seizure without bringing the warrant of arrest from the competent authority. There is no such whisper. That apart, from the entire written complaint, there is no whisper at all that the search and seizure was under videograph, nor there is mention regarding the ground of arrest, neither in the memo of arrest nor in the written form. My lord, here in this case, the petitioner is languishing behind the bar since 8/12/2024. Meanwhile, charge sheet has submitted against the two accused persons. And in respect of the other accused person, WA is still pending. So it can safely be presumed there is no possibility for conclusion of the trial immediately, since when against one of the accused person is WA is pending. My lord, considering the fact that there is no mentioning as regards to the reason to believe, there is an utter violation of section 42 of the NDPS Act. There is no mentioning as regards to the ground of arrest, that is a violation of the order passed in the case of DK Basubai or Apex Court. There is no mentioning as regards to the fact that the entire search and seizure had done under videograph. And one of the accused still at large, and there is no possibility of conclusion of trial. Considering all this aspect, considering my period of detention, allow this accused petition with bail at any stringent condition.
okay.
My lord, 100 bottles of codeine phosphate was recovered from exclusive possession from this petitioner, my lord. My lord, as per provision, my lord, inventory done, certificate of correctness also received, and my lord, sample sent, and my lord, the CFSL report also collected. After collection of the CFSL report within the stipulated time, charge sheet filed, my lord. And my lord, one person still absconding, that is true, my lord. That is why, my lord, the trial cannot be proceeded. It's true, my lord, but 82 CRPC is there, my lord, maybe split up.
84 of the
Yeah. 84 of the BNS.
Okay, please take down. Learned counsel for the petitioner submits that the petitioner is in custody since 8/12/2024 in connection with a NDPS case. One co-accused person was yet to be apprehended by the investigating agency. Full stop. The seizure was made from 1:15 hours to 1.45 hours. There are no explanation by the investigating agency why the seizure was made in these periods without the specific warrant of arrest from the appropriate authority. He further submits that though the present petitioner is in custody for a long time, the trial could not be proceeded as one of the accused person is not apprehended. Proceeded as one of the accused person was not apprehended by the authority. So he pled for bail in any condition. Learned counsel appearing on behalf of the state raised strong objection and submits that huge quantity of phencyl cough syrup bottle. Cough syrup of 100 bottles were seized from the possession of the petitioner. Full stop. The investigation of the police is ended in charge sheet. CSA, full stop. CFSL report has already been reached and the charge sheet has been submitted.
Yes.
Having heard the learned counsel for the parties, considering the entire fact, the full stop. The allegation raised by the petitioner regarding date and time of seizure and other materials thereon may be the subject matter of the trial. But at this juncture, as there is sufficient materials in the city, I find no justification to enlarge the petition on bail. According to the bail period, the petition is considered and rejected. However, the investigating agency may split up the trial according to the law.
Grateful.
Good.
Yes,
My lord, in 26, my lord.
Call the next matter.
26. My lord, CD is not here, my lord. Kindly fix it on 4th, my lord. The same matter in connection with this NDPS case has been fixed on 4th, my lord.
4th.
Yes,
4th means Thursday,
Friday.
Friday.
Yes.
Okay. On the prayer of the learned counsel for the state. The
State,
matter
my lord, I am for NCB.
NCB. Okay. Learned counsel for the NCB. The matter be appear in the list on 4th of July 2025 under the same heading. এই লিস্টে শেষ করেন দেখেন চারটে আছে দেখেন
27.
27, I am for the petition lordship, I am saying for not this week.
not this week. Next.
28. No? I am for the student.
Lordship, this is a case of NDPS. I am in custody for 176 days. Lordship, this is page 8. Can you visit page 8? That is the written complaint. 4 accused persons, including this petitioner, was apprehended by the police. And kindly comes to page 9, second paragraph in the middle portion. May I point out? Starting from thereafter. Page 9, second paragraph, middle portion.
Yes.
Thereafter, middle portion, as per direction of
thereafter.
as per direction of executive magistrate, I searched for detained persons individually, and during search, I found 2 packets tightly wrapped and covered with light brown color paper, and each wrapped packet contained total 10 black color airtight mini plastic packets, total 20 packets. Now the question is, Lordship, 4 persons, they searched the body. 2 packets were found in which mini packets were there. From whom is not mentioned.
Very good.
Now, Lordship, finally coming down to page 10. This is a seizure list. From whom seized? Can you see from whom seized? Seizure from the possession of Maruf Mia, son of I am not Maruf Mia, Lordship. My case, I have pleaded in para 5, Lordship.
Para 5 of?
My petition.
Para 5. Now going to page 5.
My case is at para 5.
Paragraph 5.
5 of my petition, I have pleaded my case.
Yes.
The petitioner says that he is a daily labor lordship, and on the day, he along with some friends were gossiping and discussing in front of a place where a local boy also came. And subsequently, raid was conducted, and that local boy, that is Maruf Mia, from his possession, the articles were seized. Now, my humble submission, lordship. It is the case of the prosecution that the entire material has been seized from a particular person. Now, lordship, hypothetically, if lordship only considers that some persons are gossiping, police raids, and from one person the articles are found. To attract the conscious possession, lordship knows better than anyone present in this court that the prosecution has to establish that the other persons who were apprehended at that juncture were in total knowledge of the articles that were kept there. In absence of the same, only being present at this spot and articles seized from a particular person, and if the raised persons are arrested, lordship, I humbly submit, lordship, in absence of any cogent evidence collected by the prosecution regarding their knowledge of the same, apart from the co-accused statement, lordship,
Yes,
this is misuse of power.
Lordship, my learned friend has argued at length. The crux of the argument lies on the fact that nothing has been seized from the possession of this person. And the section 50 of NDPS notice was served to the person from whom the contraband was seized. This is the crux of the argument. My first, in reply, I should say that this is not the case where the name of this accused person was stated from the mouth of the co-accused, from whom the contraband was seized. This is the case where the name of this accused persons appeared in the formal FIR. This is the case where the name of this accused persons appeared in the FIR. Now, lordship, I am relying on that page which my learned friend has relied. Page 8. Page 8. Last para.
Yes, Rashid.
Held raid at the PhD construction site at Modho Shitalkuchi against the suspected person, during which initially the suspected persons tried to flee away, but we somehow managed to detain them. Detain the above noted 4 accused persons. That means these accused persons were this petitioner named says Sheikh Rejaul Ashik was apprehended on the place of occurrence. That means he's sharing a common intention, and at this stage the charge sheet has not been submitted. Today is 176 days. After 180 days, if there is no prayer, if there is no prayer for the extension of time for filing of the final report, in that case he will get the benefit of the statutory bill. But at this stage the plea of nothing has been seized from my possession. But this is not the case also on the other hand, that the name of this accused petitioner was uttered by another co-accused. If it had been so, I should have submit before your lordship that this accused petitioner should not languish behind the bar. But this is the case where the accused petitioner was present on the spot, and his name appeared in the formal FIR and FIR, and investigation is still on.
Okay.
Lordship, in reply, may I give only 1 second?
Yes.
What prevented I asked a question to myself, what prevented the state to mention in the seizure list that the articles were seized from all 4 accused persons? Why a particular name has been mentioned that from whose possession the articles were recovered? And in the case study, that what I have submitted, lordship knows that my knowledge regarding the articles kept by that person has to be established.
Okay.
Lordship, by one reply, lordship.
Again, reply against reply. Hard. Please take down. Learned counsel for the petitioner submits that the petitioner is in custody for
176 days.
176 days. He submits that on January 4, 2025, about 9:35 hours, present petitioner along with other 3 accused persons were apprehended. The police has conducted search. The contraband articles were seized from the possession of one accused, namely Maruf Mia. Full stop. He submits that the petitioner was unaware about the possession of contraband articles by said Maruf Mia, and he is a daily laborer by occupation. The police has apprehended him in connection with this case, and he has been falsely implicated. So he prayed for bail in any condition. Learned counsel appearing on behalf of the state raised strong objection and submits that the petitioner was apprehended on spot. Full stop. Though the
Named in FIR.
Nothing has been seized from the possession of the petitioner, but at this juncture, when the charge sheet has not yet been submitted, the welfare of the present petitioner cannot be considered. Full stop. Having heard the learned counsel for the parties, considering the materials, it appears that the contraband articles was seized from one of the co-accused persons. Admittedly, nothing has been seized from the possession of the petitioner. Whether there is whether the petitioner has conscious possession of the present contraband articles, or he has the knowledge of the contraband articles as seized from the other co-accused person, is a matter of trial. Moreover, at this stage, the bail prayer of the petitioner cannot be considered. I don't, the bail prayer of the petitioner is considered and rejected. Not this week.
I'm for the state, my lord. I'm holding the CD. It's a NDPS case, my lord.
No one is there.
Two
Not
times
this week.
rejected.
Next. Same, not this week.
31, my lord. 31,
Yeah.
my lord. I'm appealing on behalf of the petitioner, my lord. I'm being led by Mr. Ujjal Rai, my lord. He's on leg at Kotum number, my lord, 8, my lord. I was praying for only 1 day's accommodations, my lord.
Okay, very well, not today.
Grateful, my lord. I'm so grateful.
31, my lord.
No bail application. What are we? No bail application today.
Yes, my lord.
Next.
Item number 50.
50 এবার নেবে না বেল অ্যাপ্লিকেশন নেবেন না পাসওয়ার্ড নেই
My lord, item number 50.
হ্যাঁ 50
My lord, item number 50, I beg to appear for the petitioner. My lord, am I audible?
Yes.
Yes, my lord, I'm just praying for just not today. Tomorrow I will be there at circuit. I want to do the matter by present in the courtroom, my lord. Just not today, my lord. Grateful, my lord.
My lord, I beg to appear on behalf of the petitioner. My lord, in this matter, I pray for your lordship's leave to file supplementary affidavit to bring some relevant documents in the record. As because, my lord, an order of interim maintenance is under challenge, and while passing the order of interim maintenance, the assets and liabilities of the husband was not taken into consideration. My lord, the assets and liabilities filed for the trial, filed for the, my lord, to oversight. I could not annex the assets and liabilities filed before the trial court with this revisional application. But hence, I will have supplement.
On the prayer of the learned counsel for the petitioner. No, on the no. Learned counsel for the petitioner be permitted to use supplementary affidavit in connection with the CRR within 2 weeks hence. Full stop. The petitioner shall serve the supplementary affidavit upon the opposite parties and file an affidavit of service on the returnable bill. Let the matter appear in the next available circuit. Next.
My lord, being briefed by the interim order as passed in the maintenance and the quantum of maintenance that was decided by the court being agreed, we are filing this divisional application. My lord, in the.
You are the husband,
No, my lord, I am for the wife.
wife, you are not satisfied with the interim maintenance.
Maintenance order that has been passed. My lord, the opposite party number two, that is the husband, is a central government employee and having a handsome and is withdrawing a handsome salary of 5,000 as per my knowledge that I have. My lord, when there was a dispute in between them, there was an allegation that he had married a second wife, and during that point of dispute, what happened with the intervention of the local peoples, there was a settlement that was arrived in between the husband and the wife, whereas it was stated by the husband, my lord, that is the annexation P5, page number 20. Herein it has been stated by him that he will pay 50% of his salary for the maintenance of the wife and two children, two minor children. My lord, moreover, he has in the written objection of his 125 that is my lord in the page number 39, he has categorically stated in the subpara of para number 15 that he is paying a monthly maintenance of rupees 13,000, and moreover he is paying. He has stated out here in his written objection, that is in the page number 39, my lord. The second para of para number 15. Subpara. Whereas no payment has no furthering till date, no furthering has been given, or not a single penny has been given to the wife for the maintenance of the child or for the maintenance of the wife. My lord, he has stated here that he is paying all this EMI, which is for his home, and the policy he is maintaining LIC policies. He is stating out here, but the LIC policies, they are in the name.
No, I understand. Though 8,000 is the award. 8,000 is the interim maintenance.
1,000 for both the two.
4,000, 2,000, 2,000.
2,000, yes, my lord. That is.
So 8,000 is the interim maintenance.
Yes, my lord.
So what you want?
My lord, he is earning a sum of rupees 45,000.
Whatever maybe the matter is there.
At least 50%. He has stated, he categorically stated here that he is paying 13,000. My lord, at least a bare minimum of 20,000 interim maintenance I am seeking from this court, my lord.
He is earning 45,000 and you want 20,000. He has no other liability.
He has no other liability, as because his father has expired, mother is a pension holder, and he has no other.
So you contest the matter. You contest the matter before the court in the why interim maintenance matter?
My lord, seeking a higher maintenance from this court, my lord. That is the only prayer that I have.
I understand you seeking a higher maintenance, but what
2,000 rupees for a child is not at all bare minimum sufficient to even for his bare minimum necessities for his.
Very early, sir.
My lord.
No.
Challenging the impugned order dated 20th May 2025, passed by the learned JM Fourth Court Siliguri in respect of an interim maintenance in favor of the petitioner. The instant CRR has been preferred, having heard the learned counsel for the petitioner. I accepted the submission of the learned counsel for the. I accept the learned counsel for the petitioner that there are merits to be determined in the instant criminal division. According to the criminal division be admitted. Petitioner is directed to serve the opposite parties and file an affidavit of service on the returnable date. Let the matter appear in the list in the next available circuit. Next.
53.
Yes, who is there? 53? You are there.
For the petitioner.
You are for the petitioner.
Lordship.
Yes, what is the matter?
My lord, in a very natural, if I want to know, I may submit that it is denial to access of justice. The petitioner's husband is the owner of a particular property in Dartford. Now, there were other shareholders among the brothers and sisters, there was a partition. Some dispute and differences cropped up between the brothers and sisters, they led to certain civil litigation in fight. I'm trying to give you a very short thumbnail speech. Now, during the pendency of the civil litigation, lordship, plaintiff, there were suit counter suit, so let us take plaintiff, one of the sisters of plaintiff. Plaintiff's counsel entered into a sale transaction with the plaintiff.
Into a sale transaction.
And completely purchased, allegedly purchased a portion of the property. Now, there are two branches sought out. One was the proceeding before the bar council for improper conduct. And when this council, he tried to take possession of the so-called sold out properties, there was a struggle between the parties. So that also led to filing of criminal cases and counter criminal cases. And the proceeding before the bar council ended in handing down punishment to the council and was suspended for 7 years and is still under suspension. Now, since a council is an accused, and that too a very influential council, who happened to hold the post of the government at that time in district court of Darjeeling, the complaint that was filed by the petitioner, though it was converted into a charge sheet, but has been severely mishandled. But Lordship, may I give you one example? Charge sheeted accused was dropped. Nobody knows how. PP has no clue.
Dropped.
Dropped. Now my brothers, prosecutors are sitting. Most probably they will be shouting like madman if they don't know an accused has been dropped from the charge sheet. They will rather block the whole process if it is done without their knowledge. PP doesn't know. But surprisingly, there was a resolution passed by that particular bar that if somebody, one member of the bar is accused or some cases is pending, no advocate of that bar will accept the brief of the. For that, my lord, this husband of the petition had to run to the honorable principal bench. And his lordship, the Honorable Justice Jyotirmoy Bhattacharya passed a very sharp worded critical comment. And most of the cases have been transferred either to Siliguri or to Jalpaiguri.
Yes.
Now, the main prayer in the petition today is, my lord, that we want this criminal proceeding to be transferred to any criminal court in Siliguri or Jalpaiguri, we don't know. Out of that.
So all the cases has been transferred, you say?
Most. Only this is pending.
Only this transfer is required. Okay, you serve.
And lordship, if my lord is kind enough to come, take page 22, P2. The advocate of the petitioner is communicating that I cannot fight your case.
Cannot file your case.
You have conduct the case on foreign on behalf of you.
So, on the last occasion, before Honorable Justice Tirthankar Ghosh, my lord, our learned AAG moved an application and he was against the NCB, which is a form of central government, my lord.
Yes.
So he was not allowed until and unless he gets some permission from the chief secretary. So in that case, so that's why we are just because he holds the constitutional post, he's a DSG. And central governments, there are various offices under the central government. So it can be influenced. But in that case, my lord, this is just on the last occasion. So this is just for the knowledge of the court, nothing else. Even Justice Ghosh stated.
It comes from Constitution. One day we will hear that whether a man has got to marry, that is
Now-
something else. I don't hold a constitutional post. My friend is entirely wrong. One should be aware before what he is saying. My learned friend doesn't know how this solicitor generals are appointed.
No, no, whatever may be. So.
My lord,
Oh.
we are eligible only, we are only one bar. We cannot file any cases against the Union of India. Yes, we have a fair hand. What happened to his double edged? I am his brother. If he wants, he can complain to the Ministry of Law and Justice. He's free to do
No,
so.
that is not the issue involved in the instant writ petition.
I don't know why this comes up.
This is just for the knowledge of the court. That's
Court
not-
has this knowledge.
No,
On the last occasion, because prior to that, nobody has, no justice land has raised this question, my lord.
My lord, the
He has also
double
moved-
edged.
the double edged has also
means
moved.
additional advocate general.
Yes,
Is an
that is the
advocate
all
Even in
separate
Kolkata, my
issue.
lord, the PP, Mr. Devashish, he also requires permission. If he moves an application against the Union of India, my-
Parity.
my lord. it
Why
have been-
learned counsel shall put the
This
the
is the
sword in the
matter.
leg, in his own leg, in these matters.
Well,
Let him move.
No,
What
my
is
lord,
your
he
objection?
have just, this is not a question.
I don't know. If
Only
the
for the
double edged
knowledge
had
of-
come up and said this.
No,
I
that
don't
is
know
the
how
I'm a-
this
I'm a-
acting shining
I'm
out.
a- I'm a
all
additional
separate
public
issue,
prosecutor.
all
Fine.
separate issue.
I don't, I cannot raise this.
No, no, all separate issue in respect of the state legislature and central legislature. That is all separate issues, all separate guidelines at all.
About last 4 years, Mr. Chakraborty never found it.
But I've kept all your order sheets.
Okay.
I have all the order sheet which you have moved.
Very well.
Thank you. I asked my biographer.
Please take
I
down.
have a biographer.
Having heard the learned counsel for the petitioner, it appears that there are substantial question to be involved, appears that this is an application for transfer of Darjeeling Sodor PS case number 20 of 2010 under section 341, 448, 427, 506 IPC corresponding to GR case number 34 of 2010. Pending before the learned additional district judge, third court, Darjeeling. Having heard the checkered history of this matter regarding the transfer of several like cases from the jurisdiction of district judge, jurisdiction of Darjeeling court to the courts of Jalpaiguri and Siliguri, I find justification to entertain the instant criminal division. Accordingly, the instant criminal division be admitted. Petition is directed to serve the application, serve the copy of criminal division along with the annexures thereof to the opposite party and file an affidavit of service on the adjourned date. Let the matter appear in the list. Let the matter appear in the next available circuit.
Definitely.
Affidavit of service.
54.
Also, I'm paying for accommodation. Kindly fix the matter on Thursday.
Thursday. Very on the prayer of the petitioner, let the matter be appear in the list on the third.
Yes.
Third.
Yes.
Next.
55. Lordship, may I please, I'm for the petitioners in this matter. The instant matter is for quashing of an application that has been filed under section 200 of the CRPC, Your Lordship. There is a CR case number 514 of 2024 that is pending before the learned judicial magistrate first court at Siliguri. Now, the petitioner and the complainant.
Page.
22.
Page of the CR case.
CR case. That is the complaint petition. Page 22.
Page 22.
And
Yes.
also the certified copy attached to
Page 22. Yes.
Now, this is the complaint that she has filed under section 200 of the CRPC. The brief fact of the case is that the complainant and the petitioner number one were both the directors of a company, Your Honor. And if may I draw your honors, your lordship's kind attention to page number 35. That is the certificate of incorporation of the company. Now, page 37.
Yes.
Page 37 is the
Certificate of incorporation. Yes.
Now, the facts of the case, lordship, is that the petitioner number one and the complainant were the directors of the company with the name and style of Messrs. Embark Institute Private Limited. Now, while they were the directors, they started living together in a living relationship. Now, when they were started living in a relationship, the complainant left the said accommodation and she started staying with another man, that is, namely Prakash Shetty. Now, after that, she started raising demands of money to the petitioner number one. As far as petitioner number two is concerned, petitioner number two is the mother of the petitioner number one, and she's got no connection whatsoever with the complaint. Now, when she left the accommodation on 23rd of December 2023, she started raising exorbitant money and she filed various cases. 125 cases is pending. A case under section 12 of the domestic violence is there. Also, there was a criminal case, that is GR case number 2503, Lordship, and the Honorable Court has been pleased to stay the GR case also. I've got in page number 58, Your Lordship. A CRR case number 300 of 2024. It is pending with disposal before this Honorable Court, Lordship. Now, this is the fact of the case, Lordship. So, as I'll take you to an important aspect, that is, now, there was a direction to the police authority. If may I draw your honor's kind, your lordship's kind attention to page number 21. Now, there was a search and seizure made as per the directions passed by the learned court. In page number 21, I'll just read the relevant portion. During searching, as per schedule of the Stridhan serial number 1 to 6, did not found in the house, but the petitioner Srimati Meghasri Pradhan Ni Rai clarified that she was received serial number 7. Now, there was a vehicle. It is a fact that they were staying together in the house of the petitioner number 2 because they were in a living relationship. While they were in a living relationship, the vehicle that belonged to the complainant was there lying. Now, she already took that vehicle. Now, nothing is there in the case, Lordship. That is why I've come before this Honorable Court praying for quashing of the application, and your Lordship may be pleased to stay there in application that is below the learned. And if may I be directed to serve a copy to the opposite party number.
Okay, please take down. This is an application for quashing of a criminal proceeding being CR case number 514 of 2024 pending before the Judicial Magistrate First Court Siliguri, having heard the learned counsel for the petitioner, also considering the petition complaint under section 200 CRPC. I find there a justification to entertain the petition. However, I find no justification to stay the proceeding of the criminal case. Accordingly, the petitioner is directed to serve the application along with the connected annexures thereof upon the opposite party and file an affidavit to service on the returnable date. Let the matter go out of the list, party are liberty to mention affidavit in opposition on the returnable date. Next, let the matter go out of the list. Parties are at liberty to mention. Parties are at liberty to mention. Next.
Stay of warrant, warrant for earlier on till no step was taken for the learned advocate, there to warrant was.
The warrant is, you go there. Why stay of warrant?
Stay of warrant,
No stay of warrant.
I will, can be, hard and sometimes, this state, small, 325, 307, submitted,
When warrant was issued?
most state was, date, 7/2/2024 is, order, most state against the accused person, for this reason, warrant was issued,
In your certified copy?
yes, 7/2, top 7/2/2024. Order written, 7/2/39, first, order number 29.
What is the case about?
The case is not allegation of physical assault,
Then we go there. How many persons are there? All accused persons?
No, there are only 4 people before your lordship.
4 persons are
Before your lordship,
issue WA.
allegation.
February 2024. Now you are, today we are June 2025.
Why did not taken any steps and not informed, communicated. For the Cali City order, no steps taken. There were adjournment petition, absent petition, nothing taken. For this reason, there is also
So what?
on all cases,
What there in this CRR?
non-billable warrant for no cases. If you want to kindly give it down to SAP and there I will satisfy your lordship, there is a court of judgment by our court, apex court also.
Everything is there.
Warrant for, in all cases, non-billable.
307.
320, 307, 300.
I know the allegations are there. 326, 307. No there. No, nothing is there. Very good. Instant criminal revision has been preferred against the order of warrant of arrest issued by the learned magistrate, learned chief judicial magistrate Coach Bihar. Learned additional chief judicial magistrate Tufanganj. Learned additional chief judicial magistrate Tufanganj against the present petitioners. Having heard the learned counsel for the petitioner is directed to serve the CRR upon the opposite party and file an affidavit service on the returnable. Let the matter go out of the list. Parties are liberty to mention. The pendency of the instant criminal revision shall not bind the hands of the bind the hands of the agency to carry out the order of the learned magistrate concerned. Yes, next.
57, 57, not this week.
Not this week.
58, but I am not.
Yes.
What is the question of the proceeding, madam? Earlier it will be a 498K and P4 of the W, now 85 of the PNS, madam. But
Who are you?
I am the husband, mother-in-law, married sister-in-law, and husband of the married sister-in-law, madam. But in this is what happened, madam, on 15 March 2022, madam, husband lost a complaint against the wife, madam. As it was registered as GD, INX, and thereafter husband filed divorce suit on 3rd of July 2024. Thereafter, this de facto complaint lost 498 days, madam. There is nothing in the charge sheet, madam. There is no material, madam, to substantiate the 498, madam.
Please take down. The instant criminal revision has been preferred for quashing of a proceeding being GR case number 1677 of 2094, arising out Coach Bihar Sodor Omen Police Station case number 166 of 2024 dated September 1, 2024. Now pending before the learned court of Chief Judicial Magistrate Coach Bihar under section 85 of BNS, read with section 3 and 4 of the Dowry Prohibition Act, wherein charge sheet has been submitted against the all present petitioners. It is the contention of the learned counsel for the petitioner that the allegation in the FIR is concocted and it is the counterblast of complaint of the petitioner number one. Having heard the learned counsel for the parties, I find there are substance to entertain the instant criminal division. Upon the instant criminal division be admitted, petitioner is directed to serve the application upon the along with the annexes thereof, upon the opposite parties and file an affidavit of service on the written hold date. Let the matter appear in the list. No. Let the matter go out of the list. Parties are liberated to mention. Why limited stay?
Otherwise, I will see like charge you can and then it will take for
Okay.
it will take time for her.
Okay. The further proceeding of the GR case pending before the learned magistrate concerned be stayed for a period of 8 weeks from date. Let the matter go out of the list. Parties are liberated to mention. Next.
Order of maintenance 20,000 and 10,000. 20,000 for wife and 10,000 for children. One children. Husband did not give an opportunity to release evidence also. And I also on this point 20,000 total 30,000 amount is used. In my conception, I given direction to serve. 50,000.
When the order was passed?
Order was passed.
March 2025.
Yes, ma'am.
Have you paid something at least after passing of this order?
I have to take some specific.
You take instruction, otherwise this criminal division cannot be admitted.
Not this week, but one. Take instruction.
Not this week.
Item number 60, praying for one-day accommodation.
One-day accommodation? Not today.
You want 60 or 143. Next, P3, this 26. Some of the co-accused prayer for squashing was allowed by 48 days. And another co-accused civil dispute, allegation 420, 406, and this is case 23, 24, but 25 is the order passed.
20?
25, not 35. Next, P3.
What is the stage now?
It has not started, but once. But some other work is to be fair for Guatemala and planning on this sitting and basically using transaction of money or civil dispute, so there is no intention to defeat for 2,400 feet of person.
Please take down. The instant criminal division has been referred for quashing of a proceeding being GR number 2479 of 2022 pending before the learned judicial magistrate 4th court Siliguri corresponding to Bagdogra police station case number 250 of 2022 dated May 29, 2022 under section 447, 406, 420, 506 of IPC. Full stop. It is the contention of the learned counsel for the petitioner that a coordinate bench of this court has allowed the prayer of quashing of the case, quashing of the GR case concerned in respect of some accused persons. The present petitioner is also standing on the same footing, so he prayed for quashing of the entire criminal proceeding. Having heard the learned counsel for the petitioner. আচ্ছা কি বলেছি বলো তো? এর আগে বলেছি some of the accused person.
The present petitioner is also standing on the same.
তার আগে
It is the contention of the learned counsel for the petitioner that the coordinate bench of this court has.
A coordinate bench of this court in CRR 162 of 2022. তারপর যা আছে দেখ, ঠিক আছে? Having heard the learned counsel for the petitioner, also considering the copy of order, copy of judgment dated October 19, 2023, passed by a coordinate bench in 162 of 2022. I find there are justification to entertain the instant criminal division. According the instant criminal division be admitted. Petitioner is directed to serve the copy of application along with the annexes thereof to the opposite party and file an affidavit of service on the returnable date. Having heard the learned counsel for the next party, having heard the learned counsel for the petitioner and considering the entire material, further proceeding of the GR case number being 2479 of 2022 pending with the learned judicial magistrate 4th court Siliguri be stayed for a period of 8 weeks from date. Let the matter go out of the list. Party are liberty to mention.
Item number 62. I am for appealing for the petitioner. May it be heard on day after tomorrow.
Call the matter.
62.
Yes.
My lord, I am appearing for the petitioner.
Yes. You are for the opposite party. Yes. What is your submission?
My lord, may it be heard on day after tomorrow.
Day after tomorrow. You're praying for accommodation. Very well.
Yes, ma'am.
Day after tomorrow.
Obliged.
I'm for the petitioner, my lord. I'm for the petitioner. This is a commercial transaction, my lord, whereby both the parties entered into a commercial transaction. Opposite party number 2 supplied me the goods on credit, and thereafter, my lord, I paid some money, and then returned some
Why
goods.
did it not show argument? The argument has already been done in this matter.
My lord, petitioner has filed the written notes of arguments, but the opposite party number 2, we were supposed to file, both the parties were supposed to file on 18th of June, but the opposite party number 2 did
I
not
am
file
not inclined
on
to
9th.
file a written notes. I'm not
You are for
inclined.
the opposite party
I am
number
for the
2.
opposite party number 2. Written notes, my opposition may be treated as a written notes. No
Let the
separate.
matter be, order may be passed, maybe thereafter.
Well,
Nothing remains. my lord.
I'll be only
Just
taking
wait,
your
just
lordship
wait.
with one judgment.
Oh, I want to know what is the matter. I do not know the
Lordship.
matter.
My lord will kindly peruse
Let
the
me tell-
complaint.
let me
My
tell-
lord, may I will kindly peruse the complaint towards the end of the application, since it is attached with the certified copy, so it has not been numbered, paginated. My lord will kindly have a look at the last third or fourth page. There, my lord will find the complaint of the opposite party number 2. My lord, in the first two para, the opposite party number 2 has contended that there has been a commercial transaction whereby 19 lakh worth of goods were exchanged between the parties. Thereafter, I paid 2 lakhs rupees in cash, and thereafter returned 2,41,000 worth of goods. My lord, my lord peruses the third para of the complaint. It will in the plain
Find out
reading of
the complaint first. I could not find out.
my lord, wait a minute. This is right after the FIR, my lord. I apologize, but I cannot assist with the page number because it is attached with the certified copy.
Yes, proceed.
My lord, will kindly see the third para, my lord. The plain reading of the third para would suggest that the main grievance of the opposite party number 2 is that I owe some money to them. If that is the case, my lord, in my humble submission, proceeding under section 420 and 506 of the Indian Penal Code does not lie at all, because this is a case of civil in nature being given a criminal color. In my humble submission, my lord, the opposite party number 2 has another remedy to file an appropriate application before appropriate forum, then therefore they can seek recovery of money. And my lord, the proceeding before 420 does not lie at all, because they have failed to substantiate that how the ingredients of section 420 is attracted in this case. My lord, there has to be my lord knows that to attract the ingredients of section 420, the fraudulent inducement has to be the mens rea has to exist right from the very inception of the transaction. My lord, they have themselves admitted there has been a part payment. They may claim that there may be some part payment or major part payment. That is a different case, but there has been a part payment nonetheless. And in my humble submission, my lord, I have also attached in my main application from from page 13 to page 18, whereby I have returned the majority of the goods, and only some goods are there with me, but the majority of the goods has been returned. There, and so far as my annexures is concerned, which shows the receipt being written in the name of the opposite party number 2 proprietorship, whereby I have returned the majority of the goods. They have not dealt with that at all, neither in the opposition. My lord, kindly see page 13, my lord. Kindly page 13, and from page 13 to page 18, my annexure A is there. Those in the main application, my lord. Those are the receipts which shows that I have returned the goods to the bill world, which is the proprietorship name of the opposite party number 2. And so far as those receipts are concerned, the opposite party number 2 has not dealt with that at all. My humble submission is that, my lord, that this is a transaction of civil in nature, and proceeding under section 420 does not lie at all. My lord, even in charge sheet, my lord, to find that the IO has simply said that certain receipts have been, and they have seized certain receipts, which shows that transaction happened within the both the parties. There is a complete admission on behalf of both the parties that there has been a transaction, and those transaction receipts they have recovered. And thereafter, simply the investigating officer said that based on the discussion with the senior, they have started a proceeding under section 420 and 506. Even in charge sheet, there hasn't been a single iota of government which would substantiate the section 420 and 506 in this case lies. Lord, will kindly see my the written notes. I have cited 2 judgments which are in my favor. My Lord will kindly.
Have you not served the copy?
No, my lord. On the 18th of June, both the parties were supposed to file the written notes of arguments. My learned senior
This is the written notes of argument of the petition.
Yes,
Have you
yes,
served the copy?
May I indicate? I'm not sure. Why I'll tell you, my lord.
Then you
Because
serve
of-
him.
Why I did not, may I indicate, my lord? On 18th of June, both the parties are supposed to file their written notes of arguments. My learned senior friend did not file his written notes of arguments. That's why I could not exchange. Now, if they file, if they're saying that they do not intend to file, may I request my learned friend, Mr. Das, to hand over one of the copies of the
Hand
written
it
notes of
over
arguments?
first, otherwise how can he? How
No,
can?
my lord, today they have admitted that they do not intend to file written notes of arguments. On the 19th of June, my lord would kindly see the order of the Honorable Justice Tinthagar Ghosh. They sought time to file the written notes of arguments. Thereby I did not exchange because they have not filed the written notes of arguments on within the time.
To serve written notes of argument. And come day after.
My lord, I've given my learned friend has handed over the written notes of arguments.
Yes, what is the matter? Let me hand. Yes, yes.
I submission before the court. So this is the intention. Though they may make one part payment, in spite of that, the transaction use amount, intention is, and there is a provisions. One is criminal for the punishment, another for your recovery. But this is the case of
Yes, sir?
criminal case, my lord. Intention not to pay the argument amount. So your only thing.
Which I will demonstrate before your lordship, that a trend has started in the country where people say that in a commercial transaction.
I shall not hear you. You just receive the written
Yes,
notes
lordship,
of argument,
lordship.
thereafter it.
My lord, my lord.
It will better to.
My
okay.
lord.
Please state down argument on behalf of the petitioner as well as the state concludes. Petitioner is directed to shove the copy of written notes of argument upon the.
My lord, sir, this is correct.
Let the matter appear day after tomorrow.
My lord, may I seek one indulgence, my lord? Can the matter appear on Friday?
Why?
Friday. Friday is the very.
Last day Friday.
But then maybe tomorrow.
You have a hurry going.
Come on Wednesday. Let him submit.
I have some personal difficulty on Wednesday. my
Very
lord.
good, very good. So Friday.
But his hearing is already done. So he may appear on.
He has the right to reply.
No, I have to be there, my lord.
He has the right to reply.
My lord, would kindly record one thing, my lord.
Friday.
My lord, may kindly record one thing. My lord, may kindly record one thing that my learned senior friend does not intend to file written notes of arguments. He has said it.
Yes, sir, I shall not allow him to file.
My lord, my interim order expiring today, my lord.
You want to writing form so that.
No, not necessary.
Before the court,
Yes,
my
sir,
lord.
this is a statement before a
Yes.
learned advocate. So what is the necessary?
My
Yes.
lord, my interim order expiring today, my lord. Kindly extend the.
Interim order is there.
Yes, my lord. It is expiring today, my lord.
Interim order passed by this court on the earlier occasion be extended till the urgent day. Next.
Grateful, my lord.
64.
So in this matter, service is not effective. Next week could be better.
Very well. Not this week.
Not this.
65.
Not today.
Your Lordship, I'm for the petitioner and led by Senior Advocate Mr. Ramlesh Ray. Lordship, Honorable Justice Thakur Ghosh had passed an order on 19th June 2025, by virtue of which the interim order that was earlier granted has been extended till 31st July 2025, and the petitioners have been directed to serve opposite party number 2 afresh. The service for the same is still in process, Your Lordship. Therefore, I humbly pray before you to kindly fix the matter in the next available circuit.
Learned counsel appearing on behalf of the petitioner submits that the service is not affected. Service is not affected yet. So he paid for accommodation. Accordingly, the matter be okay. Considering the submission of the learned counsel for the petitioner, let the matter go out of the list. Party is liberty to mention.
State was also directed to serve. That has been done. We have
State?
Yes, there was a direction. Learned counsel of state is directed to effect service through the concerned police station. That we have done. And this is the report, madam. It has been served, madam.
Is there any direction?
Order number,
Okay, to effect the service to concerned police station.
500.
Okay,
That has been done.
okay. Service to concerned police station has already been effected. Report of concern SI of police placed by the learned additional public prosecutor be taken on record. Let the matter go out of the list, parties are limited to mention.
Half of the state minor.
Railways. Worship, I inform concerning department, but particular officer is not informed that kindly fix next week, Lordship.
My lord,
What is the matter?
matter, my lord, I am a salesman working in a showroom of a car, my lord. I sold my vehicle to a particular person. That particular person, my lord, it transpired had misappropriated money of railways, and with that money, my lord, that car was purchased. Now, I was nowhere involved because this is between the railways and that particular person. And since I had sold the car, I was arrested. Because I was the salesperson, my lord. So I have come for the question of the proceeding, my lord. Initially, the honorable court was pleased to stay the proceedings against me. And the last honorable bench was pleased to extend the stay till 4th of July.
4th of July.
4th of July.
So now they are seeking
Time,
time,
my lord.
taking time.
Lordship, CD is very much required, Lordship, just because they are watching. CD is also not called for, my lord.
CD.
Case record. NGP police stations case.
NGP police station case number 130 of 2024.
Yes, my lord. 130 of 2020.
Learned counsel, let's stop. Take. Learned counsel appearing on behalf of Union India submits that you are appearing on behalf of Union of India.
Lordship.
Union India submits that he needs to, Union of India seeks some accommodation for submission of report
Lordship.
from the concerned department.
Concerned department.
Full stop. Learned counsel for the petitioner seeks for extension of
Lordship, state required CD, my lord.
extension of interim order. Full stop. Learned counsel for the state seeks direction to submit the CD. Having heard the learned counsel for the parties, let the matter. No, parties, the Union of India is directed to submit a report from the Chief Commercial Inspector, New Jalpaiguri Railway Station within 2 weeks from date. Full stop. State is directed to produce the CD being NGP case number 130 of 2024 dated February 20, 2024. February 20, 2024. Within 2 weeks from date. Full stop. Let the interim order passed by this court on the earlier occasion is further extended till when the next circuit.
I'll say 21st onwards.
21st onwards. Okay. Till August 5, 2025. Or until further order, whichever is earlier.
August 5. Great.
List the matter in the next available settlement.
Grateful, Lordship.
In 68, actually, a report was called for. Actually, there was a seize of 18 buffaloes from a truck. So whether that truck, which was seized along with the 18 buffaloes, whether that truck has the sufficient space to carry that 18 compatibility, that was asked for. The IO has already prayed before the ARTO for the size of the seized truck, and and we are waiting for the order, waiting for the report, my lord.
So what is the CRR for?
CRR for release of the buffaloes.
Okay.
Grant is for release of the buffaloes.
So also I'm paying for time actually. My senior is appearing in this matter, so I'm paying for fixing this matter on Thursday.
Thursday. Particular date cannot be.
You'll be returning on that day.
So when the report would be available?
Now we have already given a requisition, my lord. I have the copy of that. So I think
Next
he has
week.
not written anything, but he has said he
Next week.
next week. It is better to
Next
have
week
next
better.
week.
Okay.
Now, my lord, I'm this order compliance of the order.
In pursuance to the direction to this court. In pursuance to the direction of this court dated 19th of June 2025, a report has been placed by the learned additional public prosecutor by ASI Khoribadi PS Darjeeling.
My lord.
By ASI Khoribadi PS Darjeeling. Let the report be taken on record. It appears from the report that the required information from ARTO Siliguri after examination of the vehicle is yet to be furnished. Full stop. Next one. The petitioner seeks accommodation. Having heard the parties, the matter be adjourned today. List the matter in the next available circuit.
Next week. The next week, yeah.
Next week.
Next week, I think.
Next week. In the next week. Under the same heading. Next.
Well, I applied for the petition for 69. And this is an application for restoration of PWDV case, which was dismissed for non-prosecution. The problem was that, my lord, on the day of dismissal, my lord, on that day an appeal was heard under 20 subsection 6, that the dates collided. While we went to for the hearing of an appeal, we have asked the court officers whether the LCR traveled or not. We were of the view that the LCR traveled. By the end of the hearing, we have heard that we have got the information the LCR did not come, and by the time we could come down to the court for giving the show cause, my lord, matter was dismissed as there was shortage of magistrate. So the magistrate went, the court went out of session a bit early. My lord, this is the list of dates, my lord. My lord, on 13th we were given the show cause for 4th. And on 4th, while we were ready with the show cause, we were heard that there was a local bar holiday for Saraswati Pujo. And my lord, on the 18th, my lord, we find out from the page number 3 the date collided, my lord. And my lord, we have been outstated from the property, my lord. I am the petitioner wife.
What about the service?
40,000 is.
Yes, my lord, service has been affected. Yes, completed.
Kindly, my lord, restores the matter. More than 40,000 rupees is pending, my lord.
Then 40,000 rupees pending.
Yes, my lord.
A sum of 3,500 was supposed to be given by the husband, lordship. I think they have not given it yet. So
Yes, my lord,
his prayer is for restoration, lordship, since the application was dismissed for non-prosecution.
This was an inadvertent mistake from our side, my lord, and we tendered our apology, my lord.
Because this is the main suit, lordship, the DV Act, against which they have gone for appeal. Since the appeal was pending, the LCR was lying there.
4th of December, 4th of February 2025 was fixed for show cause.
Yes, my lord, and we were informed by the local council that there was a sort of holiday for Saraswati Puja. Because some function had taken place on the 3rd.
So 18th March was also there.
Yes, my lord. Yes, that is the, on 18 March they appeal, the date of appeal and the date for the main should collided together, and by the time we could finish because the appeal was heard first, my lord. By the time we could finish that week and we could come down due to shortage of magistrate, my lord, the court went out of session a bit early, my lord. And my lord, and while before hearing of the appeal, we have asked the court officer, did the LCR come up or not? The court officer informed us that yes, the LCR did come up, and by the end of hearing, my lord, the judges informed us that the LCR did not travel up. So, but the appeal was heard without LCR, my lord. That is again the main problem, my lord. And due to some miscommunication, my lord, this thing happened. This is an inadvertent mistake, my lord. And my lord, if this is not restored, my lord, I have nowhere else to go, my lord. More than 40,000 rupees is pending, and by for that, my lord, even we have. Should I, my lord?
Let me see the service. Yes.
Yes, my lord. On 12th November, my lord, my lord may see the second page. Then order was passed where we have primarily had made an application for 20 subsection 6 of PWD for impeding the parties as because of irregular payment, my lord. So the magistrate on the second page, first paragraph, the learned magistrate had noted that we have preferred this application on the 9th, means September, my lord. And it took the learned magistrate like 2 months time to dispose of this application, my lord. But we are completely in mess with this matter, my lord. Kindly restore the matter, my lord. Is my
I
humble
understand
query
there is a issue, but there are 2 days so cause. Why you not there?
No, my lord. 13th
You are fighting.
13th was no, my lord. 13th.
You are fighting in the High Court, not in the Magistrate Court.
Lordship,
No,
my
no.
only prayer is like Lordship, section 29 of the DB Act, Lordship, appeal, Lordship, they can file an appeal against this order, Lordship.
I tell you, my lord. The 13th show cause was issued for 4th to answer. 4th, we were informed that there is a local bar holiday, so none of the court would be functioning. So, my lord, on the 18th, we went with the show cause. By the time the appeal was heard, was taken up first, my lord. By the time we could come down, my
It
lord,
was already expired.
this suit got dismissed, and even the contesting, even the person who was contesting in the appeal, my lord, his junior even did not inform that, my lord. They took a sheer advantage.
That is the issue. I have
Because
preferred the
I-
appeal. I would not go to the Magistrate Court.
No, my lord, we were.
You know there are so cause.
Yes, my lord.
You know there is order of so cause.
Yes, I know there is order
Then?
of so cause, my lord. By the time I could come down, my lord. By the time I could come down, my lord.
Why come down? Why someone not there in the Magistrate Court?
My lord, we have informed, but he have also missed, my lord.
No, you have not missed deliberately.
No, my lord, there is no deliberation, my lord. I must say this with entire responsibility. There is no deliberation, my lord. It is an inadvertent because, my lord, on the 18th itself, my lord, there was the appeal was being heard, my lord.
Whatever may be, appeal was heard before the High Court.
No, it was not before the High Court.
Then where it is heard?
District Court.
So District Court, you are go there, District Court, not the Magistrate Court.
My lord, by the time we could come down off the stairs, my lord, that is the delay, my lord. By the time we could, because primarily we were of the we were given the information that the LCR is lying with the court, with the district court, because the appeal
That is
was
your
heard.
wrong information.
Yes, my lord, that was the information that was given by the court officers, my lord.
Not court officer. You should have known that where is the LCR. In the appeal, there may not be a LCR. Why you prefer the appeal? Against which?
20 subsection 6, my impeding the parties because of irregular payment, my lord. More today, this day standing, my lord, there is more than 50,000 rupees pending, my lord.
40,000 आगे बोली तो 50,000 होले पण
40,000 तीन मास आगे.
चल 50,000 बोलीस नाही 40,000 बोल
Kindly disclose the matter, my lord.
Please take down.
My lord, may I interject before my lord pens down the order? She has been outfitted from her home.
Order. That is all the merits of the matter. Why we were missing that matter? Okay, please take down. Instant criminal revision has been preferred against an order dated 8 March 2025, passed by the learned Judicial Magistrate Second Court Jalpaiguri in Miss Petition case number 46 of 2024, whereby 24 under PWDV Act, whereby the case is dismissed for non-prosecution. Learned counsel for the petitioner submits that the petitioner was always diligent to proceed with this matter, but the day when the matter was appeared for show cause on 18th of March 2025, his learned advocate who represents the petitioner has missed the diary and consequently no steps has been taken. For that reason, the case was dismissed for non-prosecution. It is the contents of the learned counsel for the petitioner that on the day, that is 18th of March 2025, one appeal was supposed to be heard by the learned session judge of Jalpaiguri. The petitioner was there for hearing of the appeal. He had no knowledge about the order passed by the learned Judicial Magistrate Supreme Court. He further submits that the order, the impugned order for dismissal of the Miss Petition 46 of 2024 caused hardship. So he prayed for necessary order for setting aside the impugned order dated 18th March 2025. Next, in pursuance to the direction of this court dated 19th of June 2025, the state has submitted a report containing inter alia that the opposite parties, private opposite parties, notice upon the private opposite parties has been affected. None appears on, despite service, none appears on behalf of the private opposite parties. Considering the situation, also considering the facts narrated in the application, it appears to me that initially the show cause was issued upon the petitioner for her non-appearance on 4th of February 2025. It is the contents of the petitioner that the day, that is 4th of February, was a holiday for an occasion of Saraswati Puja. Thereafter, the date was fixed on 18th of March 2025 for filing show cause by the petitioner. Petitioner did not turn up. Consequently, the learned magistrate has dismissed the Miss case for non-prosecution. It appears to me that the petitioner was involved in dealing with the appeal before the learned session judge on that particular date. Moreover, the order of show cause was hardship upon the petitioner. Private opposite party has already been served, but despite services, they did not appear. Considering the situation, the instant I make it clear that once in situation, this is clarified that the order passed by the London magistrate is actually cause hardship upon the petitioner as she bona fidely approached before the London session judge on that day. Accordingly, the petitioner deserves a favorable order. Under the above observation, the instant CRR is disposed of. The impugned order passed by the learned magistrate on 18th of March 2025 is hereby set aside. Full stop. The miss petition number 46 of 2024 be revived in its original file and number. Full stop. Petitioner is directed to serve upon the opposite parties regarding the revival of the instant matter. And he must appear before the learned magistrate on or before July 24th, 2025 after causing service upon the opposite parties.
Ample time, Goshaw.
পাঁচশোবার কি নিবে নাকি? লেখা দেখো না পাঁচশো চলো আমি না করতাম দিতাম
Number? আমার তো নাই।
It is. Sierra. Sierra. Right to that. Shoulder. That now. All that
কাগজটা দিল না আমি হ্যাঁ তারপর দিলাম কি না আবার অনেক অনেক প্র্যাকটিস বাই করতে যেগুলো পাও ওটা লিখে আনবে এখন মাথায় এখন বসো তখন আপনি ভালো বলে দাদা ডাক্তার চিনবি ও বল দেখে না তো যাই না কি খাতাটা তুমি বলে দাদা বিশাল এটা মনে হয় আচ্ছা আমি জানি
কত বন্ধ হলো গো? 68 না? 68 মহাশয় 71 and 72 কোনো ফুটে মামলা হচ্ছে না এখানে টাকা ভোটে নাই টাকা দাও হয় টাকা দাও হয় আমি ইনস্ট্রাকশন নিয়ে একজন ফোকাল মার্কেটার সিঙ্গেল সরি পিরিয়ডের আগে
No. Not as well the Jalpaiguri road, Jalpaiguri.
One matter, Lordship. Lordship, this was I tried to mention in the morning. There was a mistake on my part, Lordship. Lordship, this matter has not been admitted yet, and an audit is required from your Lordship for serve the copy upon the state. Kindly admit this, Lordship.
What is this?
Lordship, this is CR, Lordship. There was a mistake on my part. This has not been admitted, and an audit is required to serve in the opposite party.
Okay. Motion.
Grateful, Lordship.
Call the list.
I'm paying for not to.
70 not today.
71, I'm the state of the case of complaint petitioner. Last petition may not directed to serve again upon the one advocate of years. He was here, my lord. Directors, director, my lord, the key estate, the alleged non-payment of provision fund, used my lord. On record shows that I have died before the alleged period.
So whether you have served.
Yes, initially it was served, then the Nagara council, Sir Raya Master was again served, but he was here. I think, some other police case has been called. The lordship can pass it on and follow.
This is.
Yes, sir. 25. Yes, sir. Affidavit of service is on record. This was, my lord, pursuant to the last order. It was served upon the.
You are for quashing.
the entire amount also has been paid. But here, my lord, this item number 71, I have retired my lord before this period. Now that I could not annex my retirement order, this has been downloaded from the website of the company affairs, my lord, this is the printout of the master data. Thank you, my lord. Here, my lord, at the bottom of the page, can you see there are 4 names and I have the serial number 3. Now, end date is 1st of January 2015. Now, the alleged period of offence is from February 2015 to July 2015.
February to July 2015.
January 2000. Serial number 3, my lord, Maya Production.
So where is OP number 2?
Was actually sitting with me.
Very well. Let it pass it over.
72 also same fair side.
Okay, pass it over. Both the matter pass over. 71 and 72. Pass over.
73, my lord, for item number 7, praying for next week.
Not this week.
Not this one.
My lord, sorry to the other sets has come. 71 and 70.
Very well. Take up these matters.
71. Yes. Yeah.
Last topic, I was instructed to depend on the covenant of the source. I couldn't get any information to you today. Can you give me one? In this point,
Whether you have been served.
Yes.
Receive all the copies.
My land and
So what is your submission?
Payment has already been done. But so far my information, I didn't collect the whether the payment has been done or not. Therefore, first can you give one? On this Monday, I can give.
Is it possible within Monday you can take the instructions? Please take down.
My lord, the interim protection is till Friday.
In fact, yes. Mr. Bhaskar Roy Mahasaya, learned advocate, appearing on behalf of respondent opposite party number 2, seeks accommodation for getting instruction from the authority concerned. According the matter be adjourned today. Is the matter on 8th day of July 2025. Under the same heading.
The interim order, my lord, will get expired
Okay.
by that time.
Interim order passed by this court on the earlier occasion is further extended till 30th of July 2025 or until further whichever is earlier.
72 was a similar order.
72 and 71. Both
Yes.
similar order. 71 and 72.
In 72 also, my lord, the interim stay was till 4th. Great.
Same order.
Great.
Similar order. Till 30th of July.
Four.
On 9th of July. Maybe
9th of July. Next week. You are the petitioner.
I have for the state power.
How 9th of July can be heard and the order can be passed on that? 74.
Yes.
You are?
Depend on complaint, I will read the last article. And I knew it is in the order. There was for fixed for value of the letter or a total to CFSL. Because the CFSL was sent for
examination in 2021, it has not come. The report was waiting for the report. My submission is the last day on the 19th also date of adjournment. The recess time. So I can again.
No, madam, one matter is that on the 9th, I cannot hear out the matter because I have to dispose of the matter if I hear it out. So I proceed to hear this, the applications, content application in this week. So that the order can be passed. Yes, what can be done? Only Monday it can be accommodated.
Only 19th was the last date. Similar submission was done. It was assured that it will be heard today. This.
There, but the matter was not called on the table.
Very well, let's try. An accommodation is sought for on behalf of the petitioner. Strong objection raised on behalf of the de facto complainant. Let the matter appear in the list under the same heading on 9th day of July 2025.
Madam, I was coming from Guwahati, if you see. So details may be fixed on. I will going to Delhi today, tomorrow. Is it all is fixed on? We stay on 10th or 9th?
9th I am fixing.
But then my final submission, the court permits, the CFSL report has come or not? Then part
I am not entering the merit of this matter now.
of that,
Next.
74, 875.
This is my applicant, this is my affidavit of service. This matter, this criminal division was admitted this lady to the against the asserting the order rejection of my Naraji petition against a charge sheet. No, my lord. My lord, if the my lord, 2nd August is a date fixed, my lord, then my lord impugned charge sheet, my lord kindly give my lord stay of the impugned charge sheet, which I have. Yes. 2nd August is a date fixed, my lord, there will be a problem, my lord, then I will go back to the Kolkata. Then my lord, next circuit date, but in the meantime, there will be a stay, if is sought for an accommodation. Okay, then my lord, I will proceed. Then I will proceed. My lord, 26/8/2024, the complaint give rise to a case under section 3.
No, issue is that the CD is required to be perused.
Yes.
So,
My lord, city is required to be produced. 2nd August, the date fixed before the court below. Because
for what? 2nd August?
for the charge hearing, for the charge.
2nd August is.
Yes.
There are, before that, there is another circuit.
So kindly give some direction, some protection to me, brother. Stay is required, my lord.
No.
Then my lord, kindly hear me a moment, my lord. Just stay is required. Then do this matter.
I am ready.
Very well.
CD is required. So CD is required. So what is the PS?
Tufanganj.
Tufanganj. So you call the CD day after tomorrow? Day after tomorrow?
My lord, I will be not here, my lord. Then this will travel.
When you will appear? When you will be available?
Next circuit, my lord. Then next circuit, my lord. My lord, it's not possible for me.
Okay.
For that reason, my lord, I am come to this.
Very well, not necessary.
Hey, my
Next
lord,
circuit.
kindly give that, my lord, that that will not put any harm to him, my lord. The impugned charge sheet, which I have a challenge in a Naraji petition. If there is no merit, my lord, kindly hear me a 2 minutes. I will give you the word is a merit or not. If there is not.
No, I understand your submission, but the CD has to be heard,
CD has to be
perused.
heard.
Otherwise, your submission cannot be taken.
Cannot be taken out, my lord. Only for that reason, since the matter has been admitted, my lord. So by the
Okay, let the matter appear in the next available circuit.
circuit, and in meantime, my lord, give the protection, my lord.
No, no protection. I can use the order, that is the stay order, but the
Not
matter has
stay, my lord, kindly give me that liberty so I can pray an adjournment if the matter is called for before the court below. Because if the charge sheet is taken effect on, then my lord, my application become infructuous. My lord, kindly understand, my lord. This is the problem. Let them undertake.
So when you will be available here,
My lord,
but he
they
will
can
not be
do it
available,
on-
that is the.
My lord, online this matter is some problem is there. My lord. That's why we are this is that.
Very well, then come on 21st. 21st. The
21st
next available circuit. It will be
21st.
starting from 21st.
21st July.
Yes.
Well,
Let the matter appear before the next available circuit.
but affidavit service is kept in the record.
Affidavit service filed on behalf of the petitioner will be kept on the record. Let the matter appear the next available circuit. In the next available circuit. Yes.
76. My lord, 76 and 77, my lord. My lord, for the petitioner, on 19th, my lord, this matter was taken up for hearing and there was a direction to serve. My lord, only difficulty is that, my lord, the service is not yet complete. My lord, kindly gives me this week. Next Monday, my lord, I'll surely do the matter, my lord.
On the prayer of the learned counsel appearing on behalf of the petitioner, matter be adjourned today. Is the matter in the next week.
Published, my lord. Published.
Next.
77.
Regarding 75
76 and 77, my lord.
Make it on 22nd July, madam, instead of 21.
I fixed it
21st
next
July.
available circuit.
Yes, 22nd July is continuation of the circuit.
Then it will be appear on 22nd.
22nd, madam, kindly date.
Next available circuit will start from 21st.
And 20.
If there is any difficulty, it will appear on 22nd.
Yeah, 21st and matter will be on 22nd.
No, I cannot fix a particular date.
Well,
I'm fixing the matter for next available circuit.
Well.
No issue. Okay. Next.
Item 77, my lord, similar prayer, my lord. 77 also, my lord.
77.
Not the 77, my lord.
Not this week.
I am
On
appearing
the prayer of the
for
learned counsel, the
Yes.
matter be urgent for this week. Next.
My lord, I beg to appear on behalf of the petitioner. My lord, the service will not be affected. So my lord, kindly fix this matter in the next available circuit.
On the prayer of the learned counsel for the petitioner, matter be
Lastly,
appeared
previously
in
also,
the next available circuit.
previous order also said copies are in the meantime.
Which order?
Previous order, Lordship.
Copy of previous order in this matter? 78.
Lordship. In the meantime.
You are appearing on
Copy-
behalf of whom?
CBI.
The petition is divided into 3 volumes, my lord, and it is more than 1,000 pages. So that is why we are taking some time, my lord, to.
Okay, it's okay. Next circuit.
Files.
Okay.
Next circuit.
Not this circuit. রাখুন না।
এই যে
Prayer of the learned counsel for the petitioner. The matter appear in the next available circuit. Very good.
Great.
Next.
79.
Yes. Which for the state have you served? Which group? Group 8. Give me the papers. Affidavit. Who is appearing for the state in these matters? तो बोलते हो ना स्टेट के दाना है
Normally we represent the state in this matter, but I I just want to inquire who is hearing actually.
Where will you appear? No issue. What is your name? Your name?
Sumit Kumar Mochi.
So,
I
from
thought
it-
that learned AGP is also appearing in this matter with Saurav Sarkar.
Saurabh Sarkar.
Key matter it is. Would supply.
Group 8 matters. Yes,
Lordship,
proceed.
can it be taken tomorrow? Mr. Shah will appear tomorrow. Mr.
Yes, what is the matter?
Well, may I pray for 2 days accommodation? My junior is sick. He is with me and all the records are with him.
2 days accommodation?
Leave
Very
the
well.
matter be taken out on Friday, my lord.
Not Friday,
As your lordship wishes.
day after tomorrow. Only day after tomorrow.
Very well.
Affidavit দিয়ে দিন আমার। Affidavit টা দিন দেবেন। Next.
80.
Time for the petitioner. On the last occasion, the state was directed to file the report in the form of an affidavit, my lord.
Pritam Das. Pratyusha Datta Chaudhary for the state. In which group this matter is? Group 6? গ্রুপটা দেখে নেন অসুবিধা নেই টেবল গ্রুপ 6 সার্ভিস petitioner to serve notice upon the learned counsel appearing for the state. Let the matter appear in the list day after tomorrow. You inform. Call the next matter.
81.
Lordship, I represent the state in this matter.
Looking for the petitioner, your lordship, this particular petition falls under group 2.
No, this is group 6 matter. এখানে
Since it is service matter.
yes, service.
Maybe mistakenly written over there. So this
Yes,
needs to be held by.
Group 2.
Group 2. So praying for release of this. Liberty to mention in the.
On the prayer of the learned counsel appearing on behalf of the petitioner, let the matter be released from the list of this court. Petitioner is at liberty to approach the appropriate bench having determination.
Lordship, state is represented.
Statutory representative লিখে দিন না।
And group six, group two matter, group six. Group two, yes.
School Service Commission is the assigned respondent.
If I can straight away have the lordship for a moment. On the lordship,
They're supposed to file the affidavit. Affidavit direction ছিল না? Commissioner উপরে। আমাদের না।
I'm just praying for a similar order. I will place my case first before my lordship. If I can have my lordship for a moment to place 26. There was.
Have you served the copy of this? The supplementary?
No, my lordship, we will do that. This supplementary affidavit basically contains couple of orders of similarly passed teachings which has been passed by the coordinate benches. I would just be taking my lordship to the fact of the case and request that let same order be passed even in my case. That is what I am questioning. If I can have my lordship for a moment on page 26.
This is group 2 matter.
Group 6.
Group 6 matter.
Service matter.
Okay. Proceed.
Lord, page 2626, which happens to be annexed at P5. Is a copy, my lord,
Yes.
of me appearing in a West Bengal Central School Service Commission examination, my lords. The status is qualified, which my lords will find is at the third row from the bottom for upper primary, and the results were published on 14th September 2016.
Yes.
Thereafter, my lord, page 27 is the intimation letter for the third phase of counseling. This, my lords, is something that has to be downloaded from the website. There was, my lords, at page 29, my lords, you find is the list of all the candidates who were called for counseling.
Yes.
Actually, what happens, my lord, that on the date of counseling, and that, my lord, should be fine, would be clear from page 41 onwards, my lords, are my medical records, and at page 44 is a letter, my lords, that I write. From page 44, my lords, the facts should be clear. This is a letter that I write to the secretary chairman. I put it in the drop box because there is no provision of receiving a letter there. I say a letter for inability to attend the third phase of counseling scheduled on 31st January 2025. Respected sir, madam, with due respect, it is to bring your kind notice that I, Srimati Gulti Burman, a candidate of waiting list of third phase counseling of subject English category SC female, rank such and such, with roll number such and such, have been selected and called for counseling scheduled on 31st January 2025. But due to my sudden health illness during this period, I somehow lapsed to visit the website, resulting in an inability to attend the counseling you fixed. In the event of 31st January 2025, while I was going through the website, I noticed it, and as you know, I am in Jalpaiguri, 600 kilometers away from Kolkata, so I couldn't reach you on that stipulated date. Under these circumstances, I just appeal your good sir to consider the matter by providing me another date of counseling. This is the letter that I write to you. Now, one thing that needs to take a note of is that the counseling, my lords, in respect of the 2016 examination happened in 2025, after 9 years. And for all these 9 years, a candidate has to be regularly looking into the website because there is no other mode of communication. So candidate has to regularly look into the website and keep himself updated all through these 9 years, whether a counseling is happening or not. Good, bad, ugly, indifferent, plots, a counseling happened. I was ill, the medical records are there, I couldn't attend the counseling. Then lords, page 45, by way of another letter, registered AD, because that is something that I dropped in the lords drop box that was there. I also informed the secretary chairman, same content, that I couldn't attend the counseling. Please look that I may be granted another opportunity of counseling. Now, in the meantime, lords, after the filing of this writ petition, in the supplementary affidavit that I have just handed over to my lordship, page 12 onwards, my lords, you find that there are certain similarly placed candidates. Similarly placed, no difference. All are untainted because my lords is aware 2016 examination has been struck down by the Honorable Supreme Court. But still not for the untainted candidates, this is the order that is getting passed by the coordinate bench. Page 12, annexure P13 notes happens to be the first order. Everything said. Affidavit of service taken on record. Petitioner participated in 2 selection processes, namely first state level selection test 2016, 9-10, first state selection 2016, upper primary. In my case, it is upper primary. For being appointed as assistant teacher in upper primary level of classes. It needs to be recorded here in view of submission made on behalf of the petitioner that petitioner was selected in both the selection process for being counseled in order to offer job of assistant teacher in class 9-10 in connection with first SLST 2016 and upper primary level of classes in connection there. Petitioner opted to be appointed as an assistant teacher in secondary section of a government aided recognized school since according to petitioner it was better opportunity. So previously in this case, she chose another opportunity to be appointed in another school as a teacher, but that was struck out. But because she appeared in both the examination, and therefore the second opportunity she didn't appear in the counseling because she was already serving as a teacher. Upper section rather than working in the upper portion. The selection process of such and such minutes has been set aside by way of the order of Supreme Court order, and then it is submitted that petitioner is an eligible candidate in terms of her respective merit position in the list of participation in counseling. It is submitted on the day of the petitioner that if the counseling which is scheduled from the 11th of June, she may be allowed to be participated, and minutes order is passed. There is objection which is raised by the the primary council board, but thereafter minutes an order is passed directing that and the relevant portion of the order page 16 minutes. In view of the aforesaid scenario, concerned authority of the West Bengal Central School Service Commission is directed to permit the petitioner to participate in the counseling. So permission was granted, primarily on 2 grounds. One is irrespective of why the absence happened, maybe because she was in a better job, or maybe she couldn't attend it because of health reason. But an opportunity has been granted in this case. And the second one was because no person should be put in a disadvantageous position. That was the reason behind it. Because of
in the matter, in this matter, 11th June was the date.
11th June was the date, and I will come to that. Next
when she was permitted to
participate.
But in your case, the date has already been over.
I will come to that.
Yes.
I will come to that. Page 18 minutes is another order. This is more similar to my case. Only one exam qualified.
Appointment.
Yes, it is not service matter, I think.
Education group.
Yes, education. This is group 2, not service matter. School Service Commission is group 2, always. Having heard the learned counsel for the parties, it appears that this the instant writ petition doesn't
classification of the
come
instant writ
under the determination of this court. Let the matter be released. Petitioner released from the list of this court. Petitioner is yet leave to approach the appropriate bench having determination. Yes.
There was direction upon the state membership to file the affidavit.
No, on the state. Sure.
For the state matter.
This matter not pertains to correction in the gradation list.
My lords, I am for Jilla Parishad, my lords, I am paying for not today.
Whether it is within my determination?
Yes, madam.
Group 5, I think. Jilla Parishad.
Group 5, and because it is service matter, therefore group 6 also should apply. Within my lordship.
So you are appearing on behalf of Jilla Parishad?
Yes, my lord.
You're supposed to file a report.
Yes, sir.
You're supposed to file a report.
Yes,
Report
my lord. I am praying for some time, my lord.
sometime means what? How many time?
1 week.
1 week. On the prayer of the learned council appearing on behalf of the Jila Parishad, respondent number? You are respondent number?
I am for the respondent of
Jila
one.
Parishad Milord is respondent number 2.
No, 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 2 is the district magistrate.
हाँ, he is the executive officer of Jila Parishad.
मुझे नहीं visit करो ये सब पता.
Group 6.
5, 6, 7, 8.
Milord, 6 groups in
5 नहीं? देखो. Yes, only group 6, 7, and 8. Not more than that.
Group 6, 7.
5 is not there. Similar order.
Same order.
Similar order.
out of list.
Go out.
Get out of list. Go out of list.
Out of list.
Out of list. Yes.
And both, this state, this is also good to matter.
Group 2 matter. Similar order.
My lord, I am praying for not today.
Whether it is within my determination. That is the only issue to be decided first.
My lord, this is the matter of group 6, my lord.
Group 6 matters. You are seeking not today.
Yes, my lord.
Where you are not today?
And the senior council is going to appear this matter tomorrow.
Very well, not today. Please take down. Not today. Not today. Not today. Next.
Lordships, in item number 86, I am appearing for the respondent. Lordships, in this case, but see, another writ petition WP 1734 or 2021 is required to be disposed of, your Lordships, at first. Both are service matter. There was a disciplinary proceedings against the BSF personnel. Now there is a 6 charges, your Lordships. Now petitioner obtained a stay order in the year 2017. Now after commencement of the circuit bench, the matter is transferred here.
I appear for the petitioner, my lords.
Lordships. Now there was a one charge, there was a charge number 125. The writ petition is pending WP 1734/2021. Now, your Lordship, subsequently on several hearing, Honorable, as per order of the Honorable Court, charge number 6 proceed by the disciplinary proceeding. Now, against the disciplinary proceedings order, this writ petition is filed, your Lordships.
In charge number 6.
Is 6. In charge number 125, the disciplinary proceeding be not proceeded as because the order of the Honorable Court 1734. Now, in earlier order, your Lordship say
This is 1734.
166/2022. This writ petition. Today's listing, your Lordships. Now, already court affirmed that both are the de-linked, your Lordships. 1734 and 166 are de-linked. By an order, your Lordships, last this matter came up for 1st February 2024. In the 1734, your Lordship, we have
1734 166.
Yes, Lordship, because earlier, your Lordship, matter is came up both. We praised before the order and demonstrate, your Lordship, both our matter is different. So 1734 is required to be disposed of, your Lordship, and dealing the matter. Now, as per order, both the matter is separately delinked. Now, your Lordship, 1734/2021, we have already preferred and can application for vacating the stay. That was pending. So my humble submission, your lordship, in this case, we have already filed an evidence in opposition. They get the time for reply. Now in 1924 to 2025 June, they did not turn up with the reply, your lordships. That is the position.
My lordships, the writ petitioner, my lords, was undergoing serious medical condition, my lords. He was on ventilator, my lords, for substantial periods, my lords, and he is now slowly recovering. My lords, I am only praying, my lords, that a short extension may be given, my lords, so that I can affirm my affidavit. Affidavit is ready long back, my lords, but due to the medical condition of the petitioner, my lords, it could not be affirmed. I only require some time, my lords, so that it can be affirmed, and then this matter can be heard out, my lords. They took more than 2 years, my lords, to file this affidavit, my lords, their affidavit. Not going on all that, my lords. The medical condition of the petitioner, my lords, extremely serious, my lords. He was on ventilator in their hospital, my lords, in the BSF hospital, my lords. Now, subsequently, my lords, by God's grace, he has recovered, my lords. Slowly, my lords, because of he has actually developed cancer, my lords, which has relapsed. So that is the situation, my lords, unfortunate situation. So I'm praying some time, my lords, so that we can affirm the.
Very good. Now see situation has
See,
come.
maybe, lordship, my humble prayer, your lordship, kindly WPA 34/2021 along with the CAN 6, kindly your lordship be listed, your lordship. Maybe separately today or tomorrow or day after tomorrow. 166, your lordship, already the charge number 6, disciplinary proceeding completed against which they came up. So I am not, lordship, 166, the
Both
matter.
are urgent. Both are urgent. In this writ petition, my lords, they
Both
have.
are separate.
Sir, one second, sir. I'm not interrupting when you are speaking. Please don't. Uh, my lords, in this matter also, my lords, what they have done, my lords, in gross abuse of their power, my lords, my rank, my lords, has been substantially reduced, my lords, because of which, my lords, my entire career is now affected, my lords. They have been acting extremely vindictively against this writ petitioner, my lords. There have been earlier writ petitions, my lords, where this honorable court has struck down their charge sheet, my lords. They went up in appeal, my lords. That appeal they have, after 3 years, they went up in appeal. That appeal was dismissed for default. All kinds of facts, my lords. We'll place all the facts before my lords. My lords, kindly let both these matters, my lords, appear together, my lords, for hearing, my lords, and we will conclude my lords, the entire issue, my lords. My lords will kindly keep it, my lords. After 10 days, my lords, I will see if power of attorney holder can be used to affirm the affidavit. It is already ready. I will see if I will try, my lords, if the power of attorney holder can be used to affirm the reply, my lords, to their opposition, and my lords can hear out both the writ petitions and dispose of it together. My lords will kindly fix a date, my lords. It's been a long time. We are suffering, my lords, because of this pendency, my lords. Humbly, I beseech, my lords, if a date can be fixed, my lords, for hearing out these two matters, my lords.
No, since January 2024,
lordship,
the order speaks, the similar submission is made on behalf of the respondent authority for separating both the writ petitions.
Yeah, lordship, separate. I have both.
No,
They want to move it separately. I don't know why, my lords. What is the point in moving
because the matter is separate.
My lords, I'll explain.
Tag.
No, so earlier occasion tag, subsequently we pay before the court and demonstrate that both the matters are tagged. One charge number 125 DCP proceeding is pending because of the on the basis of the court's order.
So whose instance both the matter are tagged?
Lordship's writ petitioner, sir.
Petitioner, my lords. My lords, because, my lords, what I will
But
submit, my
matter
lords.
is, we have facing troubles, your lordship. Charge number 125 disciplinary proceeding is pending since 2017.
Lords, after a substantial period, my lords, now they have come up with the vacating application, my lords. We will
As
answer.
and when we are trying to dispose of the matter, they come up with.
No, we are not standing. I am saying I want to get the matter heard, my lords. Why will I stand in the matter? In the matter being heard out, my lords?
Lordships, in this matter, Honorable Justice Vivek Chaudhary.
I am beseeching my lords, please
the
kindly fix
matter.
the date, my lords.
On that time, your lordship, we
I
have
am not
put a
shying
can
away, my lords.
application for vacating of the stay as because the writ is pending, say, year 2 years.
I am not shying away from hearing of the writ petition. I am submitting before my lords that both the writ petition may be fixed, my lords, on any convenient day, my lords, next week. I will, my lords, try and file my reply anyhow, my lords, through a power of attorney holder, and then my lords can hear out both the matters, my lords. It will kindly give some time, my lords, and hear out both the matters, my lords, pending for a long, long time, my lords.
1734 is of 2021
2021.
and WPA 166
2022
is
both are separate. Kindly list the matter, both are separately. On the Monday, if your lordship, as per the writ petitioner, next day, they are praying for next day, next week. Then Monday, your lordships, both the petition will listed, writ petition separately. This matter heard by separately. Charge number 125, disciplinary is pending. 166, charge number 6, disciplinary proceeding completed against the order of the disciplinary proceeding.
I'm sorry, I got disconnected, my lords. My lords, I will just shortly summarize, my lords, what has
I
happened.
understand. I am not required to be summarized. Everything I have understand. The
Yes.
issue is that only one writ petition was listed.
Yes, lordship.
166-2022.
22 has.
Only this writ petition was
Lordship.
listed, not 1734.
1734, your lordship.
Why not? Why both the writ petition are not listed?
My lords will list both the writ
Kindly
petitions.
be listed, your lordship.
Very well. Please
My
take
lords will kindly list both the writ petitions, my lords. And my lords will give me, my lords, 10 days time, my lords. I will somehow, my lords, file my reply, my lords.
It appears from the argument, learned counsel appearing on behalf of the parties submits that there are two writ petitions which were taken up together by this court at the instance of the petitioner. With a writ petition number WP, there are two writ petitions. We can look video. Video writ petition number WPA 1734 of 2021 and WPA 166 of 2022. It appears that the WPA number 1734 2021 was not listed. Let WPA 1734 of 2021 be listed along with WPA 166 2022.
Lot.
On July 8, 2025. July 8.
Lordship, both are listed, but
My lords will be pleased to fix a time, my lords, at 2 p.m., my lords.
Lordship, both separately listed, your lordship.
We will come there and physically do the matter, my lords, and finish it up for once and all.
Separately cannot be listed. Several orders are there for
yes, for
joint
listing
order.
and dealing.
I don't understand, my lords, what is the benefit they derive, my lords, from separating, joining, my lords, will
Just wait. Why do we argue like that?
Lordship's earlier writ petition listed analogous linked to your lordship. Now subsequently we pray before the Lord. Several order is passed only for why the delink is required. Already there was an order for delink, your lordship, both the matters. Kindly.
Where is the order for delink?
Lordship. 3rd January 2024. The petitioner has filed two writ petition challenging charge number 125 in W. This writ 166. I am pressing your lordship. 3rd January 2024's order has filed two writ petition challenging charge number 125 in WPA 1734 and charge number 6 in WPA 16 2022. Since the charge number 125 and 6 are different, this court on the representation made by the Respondents Council DTAG 166 2022. Accordingly, the matter was listed today. When the matter was taken up, then they adjourned, seek for time.
It is being heard together, then delinked. My lords, my only prayer, there is no necessity of linking or delinking. My lords will kindly place both the records together, my lords, after one after the other, and my lords will hear it out, my lords. I will show, my lords, how they are interconnected, my lords.
Not along with. কি বললাম কি লিস্টেড করতে বললাম along with the cutoff. We listed on 8th of July 2025. So what is the status of the affidavit in these matters? In both the matters?
1734 is completed.
It's complete, my lords.
And 166 reply.
166 reply only.
Okay, full stop. এটা হলো এটা কি 1732 করবে অর্ডার করছে 166 এ Water coach 166 এটাতে item number
I know 86 your lordship.
86 only, that is 166 হয়েছে? Learned Counsel appearing on behalf of Union of India submits that both the merit of both read petitions being 166/2022 and WPA 1734 of 2021 are different. Full stop. Mr. Learned Counsel appearing on behalf of the petitioner submits that reply in connection with the affidavit in connection, reply in response to the affidavit in opposition of the respondent authority in WPA 166/2022 cannot be placed due to serious medical condition of the petitioner. So he seeks accommodation. Let the matter appear in the list on 8th of July 2025 under the same heading. The petitioner to submit reply on the urgent date. The hearing of both the read petitions shall be taken up together on the urgent date.
It will be pleased to fix a time, my lords, so that it can be heard out, my lords. We will, my lords, come and finish it off, my lords.
No time.
I'm grateful, my lords.
So দুটো আলাদা হবে।
Then some precedence may be given, my lords, if on the top of the list or something can be given, my lords.
দুটো আলাদা রিট পিটিশনে দুটো নাম্বার করুন, ঠিক আছে?
I was humbly praying if some precedence can be given, my lords, on that date, my lords, for these matters, my lords.
For hearing?
Yes, my lords.
Your item is item number
86. 86.
It will appear on 8th on the top of the hearing.
Best. It can be done, my lords, if on the top, my lords.
Not top, order
So that we will,
not
so
there
that we
like
will come physically, my lords, and finish it off, my lords.
the computer will take it at the top. That is the, as it is appearing for hearing in the second. Yes, next.
I'm grateful, my lords.
87/91 lordship, in 87 to 90 there is affidavit in opposition is ready, your lordship. We have served earlier to the other side. Today I have lordship. Number গুলো দেখে দেই না।
Which for the petitioners? Let me ascertain whether it is within my determination. Within my determination or not?
Group 9.
Group 9.
Then there is not affidavit is ready, your lordship. Issued ready, right?
Group 9. Only 6, 7, 8 is with me. Group 9. Group, no, group 9.
Salt commission.
All group 9.
All are group 9. 87, 88, 89, 90, 91.
87 to 91.
Group 9.
It appears that these matters is not within the determination of this court. Let the matters be released from the list of this court. Petitioner is at leave to approach the appropriate bench having determination.
Lordship, Union of India representative.
I'm grateful.
Lordships, in 19, item number 19(2), Lordships, I have some difficulties there. There was a direction for affidavit in opposition. The matter relating to Katihar NF Railway RPF department, but I am unable to file, your lordships, due to communication, your lordship. We have already earlier officers, I have communicated the matter, but your lordship, the office did not turn up. Matter is pending since long, your lordship. 2 or 3 writ petition, earlier 1 writ petition filed, subsequently withdrawn. Now second writ petition filed relating to service 2007, 2008 disciplinary proceedings, your lordships. So, your lordship, my humble prayer, your lordships, if your lordship direct the writ petitioner to serve the copy directly to the department.
They have already served.
No, already we have received from the DSG office. They serve the copy to the DSG office. We have
And-
appeared, your lordship.
Then why you again want the copy?
Your lordship.
You have already received the copy?
Yes, you have already
Who is for
received
the
the
petitioner?
copy, your lordships.
Then what is your matter? Why the affidavit is not ready?
ডিপার্টমেন্টে কোনো ফোনে যোগাযোগ করতে পারে ডিপার্টমেন্টে সার্ভিস করেনি ওরা, এটাই তো প্রবলেম। ডিপার্টমেন্টে সার্ভিস করলে তো হয়ে যেত। 6-7 প্রসিডিং তো দিতে হয়, নিয়ম তাই।
Already last chance has expired.
Lordship, every day. Lordship, this is my difficulties. Without instructions, how I lordship draft the copy. Earlier writ petition.
Who is appearing for the petitioner? Mr.
Lordship, councils are changed time to time.
Arijit
Last
Ghosh.
time Arijit Ghosh, earlier Calcutta Pratik Ghosh, Pratik Majumdar, once upon a Hillol Shah Poddar. There is change of the council, your lordship, time to time.
Now today no one is appearing today.
One matter, Vishnudev Thakur, 2 matters are pending, your lordship, since long. But I am unable to file the affidavit in opposition due to, your lordship, if the petitioner serve the copy to the department directly, then department, your lordship, what?
So where they serve?
DSG office, your lordship. We have received the copy in the DSG office.
What department you are saying?
Lordships, railway department, maybe. RPM.
Director General Railways Protection Force.
Lordship, RPF Katihar division, your lordship. Matter was filed, 1 writ petition, subsequently withdrew, subsequently another writ petition filed, that was dismissed, that was subsequently restored. That's my humble request, your lordship, kindly.
Katihar is the respondent number 4.
Lordship.
They have served.
Chief Commissioner.
They have served upon the Senior Security Commissioner, Railway Protection Force.
Unable to, they did not come up down.
They have already served. None appears on behalf of the petitioner. Let the matter appear the next week.
For the petitioner.
Hello, in this matter, for the respondent number 7, Mr. Himadri Shekhar Chakraborty will appear, my lord. Kindly place this matter next week.
My lordship, because this is a matter of 2023.
What is the matter?
Group?
Group?
Group 8, because they have doing this since 2023. That's why the Honorable Court has imposed cost upon them funds. These all orders with me. Even then they did not file any opposition. In a very nutshell, I am placing this case before your lordship. Then your lordship will understand. They will never file any affidavit in opposition. Because my lord, a notification published for my lord the license of the fair price shop. The notification, it is specifically stated the eligibility and the eligibility criteria. And in that criteria, it is specifically stated the person who is.
Who are you?
My lord, I am one of the candidates.
One of the applicant.
One of the failed candidate, lordship. Now, the private respondent who has been selected, he is my lord, he is the person, my lord, I have made him party as the respondent number 7.
Who is appearing for respondent number 7?
Yes, my lord. Mr. Himadri Shekhar Chakraborty will appear.
They are,
Who is for the state?
My lord, I am for the state. Let me.
some state file the report. From the report, your lordship will get, my lord, how genuine I am. Because my lord, the notification, the ineligibility criteria, it has been specifically stated. The applicant whose near relative has already fair price shop, he will not be eligible to apply for the fair price shop. Now, my lord, that near relative has also been, my lord, described that who will be the near relatives. There, my lord, specifically it has been stated that the applicant's sister's husband, sister's spouse, if he has already the fair price shop, then the applicant will not be eligible to apply for the same. Here, my lord, this is the second round of litigation. In the earlier litigations, I have enclosed all the documents from which it is evident that the applicant's sister's husband had already a fair price shop, So, my lord, so according to the notification, applicant is not eligible for the for getting the license of the fair price shop because his sister husband has already the fair price shop. Now, lordships, this is the second round of litigation. Here, your lordships, the report has come up from the side of the state where it has been from which your lordships will get the private respondent who has got the license. His name is Vishnu Pada Adhikari. His sister name is Kavita Adhikari and Kavita Bormon. Initially, she was Adhikari, thereafter Kavita Bormon. She married Bhavesh Chandra Bormon, who has already fair price shop. And my lord, the report of the state says that father of Kavita Bormon and Vishnu Adhikari are the same. So, my lord, Vishnu Pada Adhikari is the private respondent who has been selected for the license of the fair price shop. His sister is Kavita Bormon. Kavita Bormon husband already has the fair price shop. That has been admitted by the state in its report. So, my lord, in that way, they have been grossly violated the notification eligibility criteria of the notifications. Even then, my lord, he has got the license. So, my lord, he will never file affidavit in opposition. He will not be able to file affidavit in opposition because he cannot, my lord, deny all this by the way of affidavit. Now, my lord, if your lordships kindly allow me, I will show all the documents to your lordships. The notifications, the earlier order in the earlier writ petition, thereafter, my lord, the inquiry report, thereafter the report of the state who have my lord supporting me that yes, the person who has been selected, who is the private respondent, his sister's husband has already a fair price shop.
This is the only ground.
This is the only ground and this is the sole ground to be disqualified, lordship, as per the notification. But he has been selected, he has been given fair price shop and he is running, my lord, the fair price shop. As per the notification, my lord, he is, my lord, totally disqualified for being given the license of the fair price shop. And that has been admitted by the state in its report.
Where is the report?
Yes, your lordship, kindly comes to the report. But before that, lordship kindly comes to the earlier order in the writ petitions. Everything will be clear to your lordships. The earlier order in the earlier writ petition. Lordship kindly comes to page 59 of my writ petition, of the present writ petition. Lordship has got it.
Yes.
May I read, lordship?
Yes.
The petitioner applied for a fair price dealership license in the prescribed form pursuant to an advertisement dated such and such. The petitioner was not selected. The respondent number 7 was selected. The petitioner submits that the respondent number 7 should not be should have been disqualified as per part 3 clause 13(1) of the notification dated December 2nd, 2021. A near relative of the respondent 7 was already holding a dealership of a fair price shop. It is submitted that a near relative as per clause 2(xa) of the West Bengal Public Distribution System Maintenance Control Order 2013 would include the sister, spouse, brother-in-law of the respondent 7, Sri Bhavesh Chandra Bor. The learned and lordship kindly see now. The learned advocate for the state respondent has handed over the amended control order in which a relative under clause 2(xa) has been defined as sister, spouse amongst other. So sister, spouse is also included, my lord, as relative. It is contended that the said Bhavesh Chandra Bormon is the husband of the sister of respondent number 7. Mr. Bormon is a secretary of Mathabanga Subdivision Dealers Association and he himself runs a fair price shop. The allegation is that the selections of the respondent 7 was illegal, arbitrary and not in consonance with the notification and the control order. The learned advocate for the state respondent submits that these are the factual issues which have to be gone into by referring to the records. Learned advocate for the respondent number 7 denies or said allegations, submits that no order should be passed on rogue and omnibus allegations which are not supported by any cogent evidence. The petitioner has submitted a list of fair price shop dealers obtained from the website of the Food and Supplies Department. The list refers to one Bhavesh Chandra Bormon with code number of the fair price shop in Mathabanga. Then on page 61. Upon perusal of said documents and upon considering the notifications and the control order, this court is of the view that the allegations made by the petitioner must be poked deeper. The writ petition is disposed of with a direction upon the district controller's Food and Supplies Kujbihar to treat this writ petition as representation of the petitioner and dispose the same in accordance with law. Then while doing so, the petitioner and the respondent number 7 and
So where is the order? I understand. Where is the order?
Now, my lord, yes, thereafter, these are the note sheets. My lordship kindly comes to page 63 onwards.
Yes, we will note this to there.
Lordship has got it? The
Yes,
note sheet?
yes, yes.
63, Lordship kindly comes to the page 63. Here, my lord, they are saying Sri Jibon Bormon Mondol, a copy of electoral lordship, the second last paragraph of page 63. Second last paragraph of page 63 of my writ petition. It's handwritten, lordship, note sheet.
Yes, got it. Just read it.
Yes, yes, lordship. The second last paragraph from the bottom, lordship. Sri Jibon Bormon handed over a copy of the electoral roll to Mathabanga Assembly Constitution part such and such, wherein one Kavita Bormon at serial number 518 is listed with the name husband as as Bhavesh Bormon, not Bhavesh Bormon. The Vishnupada Adhikari has put.
Now, whether any decision was taken by the authority? Where is the decision?
Decision according to the authority that Bhavesh Bormon and Kavita Bormon, they are the husband wife. But Kavita Bormon and the Vishnupada Adhikari, who is the private respondent, they do not have any relation. So, my lord, the Bhavesh Bormon is not the brother-in-law of the private respondent. This is
Where is the order?
information.
68 of the writ petition.
Page 68, lordship kindly comes. Kavita Bormon, wife of Bhavesh Chandra Bormon, is also interrogated in connection of the matter. Kavita Bormon replies she has no brother in the name of Vishnupada Adhikari. Fully denied, lordship. I don't know Sri Vishnupada Adhikari. I have no relative relationship with Vishnupada Adhikari. This is the Kavita Bormon's version. Now, lordship, the last paragraph. Now, therefore, after comprehension of the fact and the
You are reading page 68.
68, yes, 68.
Yes. Now, therefore, after comprehension of the fact.
The answer may be taken as conclusive decision and claim of Vishnupada Adhikari may be considered. Thereafter, lordship kindly comes to page 73. This is the ration card in the name of Kavita Bormon, where your lordship will get the father of Kavita Burman and Vishnupada Adhikari is same. Is the same person. Last para of page 73. As per ration card nominal register, it appears that the ration card is recorded by folio number such and such in the name of Srimati Kavita Adhikari, daughter of Giri Shankar Adhikari. Giri Shankar Adhikari is the father of Vishnupada Adhikari, the private respondent number 7. That has also been admitted by the state in its report, Lordship. Now, Lordship kindly comes to the report of the state. Lordship has taken the report of the state.
Yes.
Now, Lordship kindly comes to the report. Paragraph number 5.
Yes.
This is the report filed by the state. That I am informed and verily believe it to be true that as per official record shown in our government portal, the head of the family of the said respondent 7 Vishnupada Adhikari is Giri Shankar Adhikari. Now, paragraph number 6. That however, pursuant to an RTI filed by the petitioner in this office to satisfy the information sought in the said RTI, I inquired the matter and collected data information from the ration card register of ex fair price crop dealer Niyamuddin Mia local resident of Lake Giri Shankar Adhikari, wherein it is appeared that Kavita Burman and the private respondent 7 Vishnupada Adhikari are the daughters and son of late Giri Shankar Adhikari. Now, Lordship, kindly comes the documents they have annexed. Next page. Page 5 of their report. Vishnupada Adhikari, serial number 4. Lordship has got it. Son of Giri Shankar Adhikari. Now, serial number 7. Kavita Burman is the daughter of Giri Shankar Adhikari. The Lordship, before that, Lordship kindly see what has been written. Lordship kindly comes to page 9 now. Page 9 of the report. Kavita Adhikari, serial number 7. Giri Shankar Adhikari, daughter. Vishnupada Adhikari, son of Giri Shankar Adhikari. So, Kavita Adhikari and Vishnupada Adhikari are the brother and sister, and Kavita Adhikari's husband is Bhavesh Chandra Burman. He has already the fair price shop that has been admitted. And Bhavesh Chandra Burman himself said that Kavita Burman is her Burman or Adhikari is his wife. So, my lord, the sister's spouse is already, my lord, running a fair price shop. And if it is so, as per the notification, he is a disqualified candidate to get the license of the fair price shop.
Okay. Yes, for the state.
My lord, may take up my affidavit, page number 35. While granting this person the license, we went for an inquiry first. During inquiry, we asked for an affidavit. This is the affidavit found by him saying that he has no relation or no with any ration dealership license holder or no relative found by him. Then my lord would come to page number 42, my lord. This is the legal heir certificate produced by the Pradhan of the Gram Panchayat. It also says that they are not brother and sister. Subsequently, during the hearing of this case, when we traced the record from the ration card, then we came to a realization that they may be the brothers and sisters. So the private respondent have to come and say whether they are actually brothers and sisters or not. Because during the entire process of our handing over our license, they have always said that they maintain this, that they are not brothers and sisters.
No, they in their report by the
No,
way
I've said that during the context of the
by
hearing.
way of affidavit. Lordship kindly sit upon that. First, they are saying no, they are not the brother and
I am not
sister.
saying anything, I am saying what they have seen, they have affirmed the affidavit and said as they are not.
Order, pursuant to the court's order, now they have come up with a report. Now they are saying yes, they are the brothers and sisters.
I said maybe.
So, my lord, the
They have
initial-
said, legal heirs, Panchayat has said they are not the brother and sister.
Lordship,
How will I trace it them all?
after filing an opposition, my lord, by the way of affidavit, is there any scope of maybe? First, they said that there is no relationship. Thereafter,
No, I have not said there is no relationship. I say as per the records, as per our inquiry,
they have come with a report, my lord, with all documents which is evident, from which it is evident that they are the brothers and sisters. And the sister's husband has already a bed pressure.
well, let the respondent come and say what is their stand. How will,
Isn't there any connivance, lordship?
not at all.
Now, lordship, kindly see the orders, how many times, my lord, the opportunity has been given to the private respondent to file their affidavit in opposition. Even, my lord, the honorable court imposed courts upon them for their conduct.
Yes. So, what is the, where is the private respondent? Yes.
Kindly place the other window next to it. It's a remote because look out to 11.
Yes, he will appear. What is your submission? I am hearing the matter now.
Yes, accepted by the court. There.
So your your affidavit and report in the form of affidavit are different.
No, my lord, during affidavit, what we have annexed that what the submission was made by the private respondent. And during inquiry, what submissions were made by the local villagers as well as the Panchayat. During that inquiry, whatever records we had, we annexed that in our affidavit. It was held that we couldn't have any conclusive evidence whether they were brothers and sisters or not because the state out denied it. Later on, we traced more records and found out that from a ration card record of earlier that they are brothers and sisters as per the ration card record. So well, now the only question is whether the private respondents are admitting their brothers and sisters. If that is there, then
They usually not admit. This is the question.
Yes, my lord.
They usually not admit. They are running the license.
Yes, my lord.
They usually not admit.
Yes.
But why the state will support them?
No, we are not supporting them.
Then
why
two affidavits are different?
One is subsequent to the queries of the court that you tell from the
Not
respondent.
query. You are supposed to file an affidavit before a court of law.
Yes, my lord.
The authority has submitted, has shown affidavit before the authority, before the High Court without knowing the consequences. On the basis of a Pradhan's report, they have submitted the affidavit.
No, my lord. Page number 20.
I shall ask all of them to come before this court and taking a proceeding against them, all of them.
My lord, this has also been done, my lord.
But on the
once,
basis
my lord.
of the entire records, what we could trace out from them. He was present, my lord. The food controller was present. He said that the entire recording was based on whatever submissions were made, whatever inquiry was made. If the entire village
disagrees that they are not brother sister. They swore an affidavit and said they are not brothers and sister. The legal certificate says they are not brother sister. I do not have any documents at the stage to prove they are not brothers and sister. Subsequently, it was stressed out, and now only question is if the brothers will be ready to cancel this license.
Then why not cancel it when you file the affidavit?
Well, my lord, I pass directions to cancel it. Will cancel it since it is pending before this honorable court.
No direction is there. Stay of everything is nothing is there.
The private respondents are appearing, my lord. There was
Private respondent may appearing.
My lord, will.
But why you are allowing one person having no authority to run the license?
No, Mr. Lord, the private respondent on the other day made a submission that they will file
Yes.
affidavit regarding whether they are not brothers
They
and
will
sisters.
file affidavit. They will file affidavit that all the things you have said is the false, bogus.
No,
they are not the relatives.
If
They
they are
will say
relatives,
so.
then it's gone. It is the
Yes, they will not
cancel
admit
list.
they are relative. That is only their option. From the beginning, they are saying whether they will admit. They will admit here. No, they will not admit here. Then
That was subsequent. My lord, may pass necessary direction. I'll ask my officer to take necessary to cancel the list.
why the courts have to pass the order? Why not the authority has taken the steps? When it appears to them that there are some documents.
In this court case condition, it ought to have been taken, man. Once
Then
this video was
court case, there is no such order like that. You have to take
ought to have
steps.
been taken.
Yes, now private respondent, what are you saying? Yes, have you deposited 5,000 rupees?
I don't know.
If you not deposited 5,000 rupees that directly earlier,
That is deposited in the earlier occasions, my lord.
where is the
That was
document?
Deposited, but the contact is same. And my lord, your lordship has rightly observed, my lord, what has been fallen from your lordship's mouth. My lord, the rent food controller, my lord, was present, my lord, personally. Thereafter, my lord, he was trashed like anything from the honorable court. Subsequently, the new report has come. Initially, that earlier one. After that, my lord, this report. So, lordship can understand, my lord, what is going on.
Yes, please take down. Day after tomorrow. Argument on behalf of the parties, argument on behalf of the petitioner, as well as the respondent authority concludes. Let the matter fixed for argument on behalf of the private respondent. It appears that in spite of several opportunity, the private respondent were not filed the affidavit in opposition. Last chance for submission of private file affidavit in opposition has already been over. Considering the situation, let the matter appear in the list day after tomorrow for further argument. The respondent is at leave to file affidavit, if any, affidavit in opposition against the writ petition, if any, within the urgent date.
Grateful, lord.
Next. Watch it mention morning. Yes, Mr. Agarwal. What is the matter? I cannot hear. শোনা যাচ্ছে না। What is the issue?
But am I audible, my lord?
Yes, now you are audible.
My lord, in the morning I mentioned this matter in anticipation that it will not be taken up. But your lordship has taken up, my lord.
Yes.
So, my lord, may I say proceed with this? Because my reply to the affidavit of the state is ready and my junior is there. He will be filing, my lord.
Okay.
Well,
you are appealing this matter? For the state?
Lordship, we seek 2 days and because reply is Mr. We have received.
2 days time, file will be filed. Our affidavit has been filed.
Affidavit in reply on behalf of the petitioner to the affidavit in opposition of the respondent number 5 is taken on record. Day after tomorrow, Mr. Agarwal?
Day after tomorrow at 3 p.m., my lord, because in the morning, my lord, your lordship knows I will have to remain. 3:30 or so, my lord, anyways.
Yes, in the same list it will appear on second half.
My lord. Second, kindly fix it 3:30, my lord, if your lordship.
See, I cannot fix like that here. You know the situation.
But my lord, if I would be in the.
Okay, I'm fixing the date. Let the matter appear in the list day after tomorrow. Under the same heading. It would appear in this time, perhaps. Next.
Sorry.
95. That's why it doesn't state. What was the name?
Who is for the petitioner? Petitioner is not.
Previous occasion also they have failed to appear.
Please take down. None appears on behalf of the petitioner. Full stop. State is represented through learned counsel, Namtanian. Full stop. It appears next. It appears from the record that on the earlier occasion, petitioners.
Lordship, here in this I am appearing on behalf of the respondent number 1. Mr. Robin.
And state respondent are represented through learned counsel, Namtanian. On the earlier occasion, it appears that the petitioner was not represented. Thus, the matter was go out of the list with a liberty to mention. The matter again appearing in the list.
1/5/2025, the state has filed its report. But the moment the report was filed, after that they have not.
State has already placed the report.
On 1/5/2025.
On 1/5/2025. Considering the circumstances and considering the conduct of the petitioner, it appears that the petitioner is not desirous to proceed further with this matter. Accordingly, it is the view of this court that the petitioner has lost interest in the instant lead petition. Accordingly, the instant lead petition is disposed of for non-appearance. Dismissed for non-appearance first. Dismissed for non-appearance, not dismissed for default. Dismissed for non-appearance.
Grateful.
Interim order, if any, passed by this court during the pendency of the writ petition is also vacated.
Grateful. Grateful. One by one.
Pass.
96, I am for the state, my lord. In this matter, my lord, there was a direction to file affidavit in opposition. I am praying 2 weeks time, my lord, to file the same. The issue
Who
is
the
pending.
petitioner?
Petitioner, my lord. They appear from Kolkata, my lord, but for few days, my lord, they have not appeared. And this issue is pending before the Honorable Division Bench, my lord, in MAT 1513.
Which group? Essential group 8.
Group 8. Group 8, madam.
I'm praying time for filing the affidavit in
Okay.
opposition, my lord. Let the matter be placed before next circuit.
None appears on behalf of the petitioner. State is represented through learned counsel such and such now. Considering the situation, let the matter go out of the list. Parties are liberty to mention.
Deeply obliged. Lord, I am for the High Court administration.
We represent the state.
This is, my lord, with regard to, my lord, the prayer for regularization of certain class of employees of this bench. So that affidavits are complete. It can be
Group
taken
six
up, my lord,
matter.
any day, yes, my lord.
Group 6 matters.
Group 6.
There you are today, tomorrow.
Grateful.
Ninety-eight and 98 two similar matters, food and supply, our affidavit is ready, we are not carrying the 2 days, we want 2 days accommodation for filing the affidavit. It is
My lord,
ready.
I am appearing on behalf of the appellant petitioner led by Ms.
Appellant.
Shatabdi Das, who is appearing
Item
on
number 98.
98,
and
99,
99.
Both.
both.
We are ready, we'll file 2 days time, you see, 2 days. time.
So come on next week. So
Yes.
why it is appearing for hearing? Hearing
I
is
don't
not
know,
ready.
because there was direction, we.
For
we have to-
filing
we have
affidavit
to
of
file-
opposition.
Filing.
You are appearing for?
For the state, my lord.
For the state.
She is in item number 98 and.
Okay. Learned counsel is appearing on behalf of the state submits that the affidavit in opposition is not ready. So the 6th time. According to the matter be adjourned to the list the matter on 7th of July 2025 under the same heading. State is liberty to, no, the time for filing affidavit in opposition is hereby extended thereby, full stop, semicolon, thereby, semicolon, no, thereby, the file to, time to file, reply against the affidavit is also extended. Similar order 97 and 98.
Yes.
98, 99.
98,
98 and 99. Yes. Next.
Lordship, here also I am appearing on behalf of the appellant petitioner led by Ms. Shatabdi Das, who is supposed to appear online from Kolkata.
My lord, seeking for an extension to file affidavit or 1 week extension, my lord.
On the prayer of the learned counsel appearing on behalf of the state, the time to file affidavit in opposition is hereby extended till 1 week from date.
Grateful.
Reply thereto, if any, by the petitioner is also, no, time to file reply is also extended for further 1 week. Let the matter go out of the list. Parties are at liberty to mention.
Lordship. Lordship, I am for the writ petitioner. Lordship, kindly says the order dated 12th March 2025, where Justice Sengupta, Justice Sengupta directed the state to file a report in the form of affidavit. Subsequently, the affidavit was supposed to be filed within 2 weeks. Now, after 2 months, 2 weeks gone, 2 months, 38/4/2025, state took another time to file affidavit in the
Yes, where is the
Lordship, their main grievance is going to be settled. It is placed before the concerned authority. That's why you are
What
not
is the
filing it.
matter? Lordship,
What is the matter?
the matter is regarding Lordship appointment.
Appointment of?
Appointment of Lordship, this technical education.
Okay.
Group 6.
Then whether you are
They are casual
deciding the
employees,
matter.
whether they can be considered that is pending before the authority. So since if it is considered, we need not file any affidavit or report. Affidavit to that
Lordship,
effect.
may I make a submission? Because the
And that can be done.
Lordship, the lackadaisical attitude of the state, kindly Lordship comes to page 33 of the petition, the representation.
Yes.
Which Lordship will find from page 40 onward. 40 is the postal receipt, and 41 onwards the track report. At least Lordship, the consideration of the represent order, if it is passed, then we can pursue the matter.
That can be done because
How long will sit, Lordship? They are not filing, not even stating that it has been placed before the appropriate authority. This should have been come before the court in form of an affidavit.
You're seeking benefit of some notification that is.
Because notifications were there where our post ought to have been something else, the salary ought to have been something else, which have been denied. Subsequently, we filed this representation. Nothing happened. Then
Who are the petitioners?
Lordship?
Who are the petitioners?
The petitioners were the teachers. That is workshop. They are given a term. Technical teachers of the Polytechnic College.
Technical teachers of Polytechnic College.
Because they are kindly come to Lordship, page 22. It will be clear, Lordship.
So what is the given?
Sometimes they are called visiting instructors. Sometimes they are called
They were all casual employees. Now they want to seek benefits of certain notification.
Since inception of the college, Lordship, more than 10 years, this was 3/11/14 notification of Lordship. The 10 years service, which has been over, no permanent post has been created, no permanent employees has been sent, but they were asked to carry forward since the inception of the college, and they are doing the same. They are not getting the benefit. Lordship, kindly see our representation. Representation, that portion which we have.
Is it covered by the judgments of this court? Division bench is judgment there. No such. No authority is there.
Lordship, page 38, A, B, C, D, E. Our
Private Polytechnic College.
No,
Government.
Government Polytechnic College.
We have
Since
notifications.
they are admittedly they were casual employees, now they sought certain benefits of the notification. Whether they will come or not, that has been placed before the authority for consideration. Since the matter is pending, we are not coming up with a.
Page 18, government of.
Let this represent.
What is the latest notification?
What is page 18?
18 is the latest notification.
Notification of 2024.
Implementation of contractual fixed remuneration of part-time lecturers and other categories of employees of government and government-sponsored polytechnic in state. Kindly see part-time lecturers and other categories of employees. For what the remuneration for at least 15 classes per week for less than 10 years is 9,000 per month. Those who have completed 10 years, there will be 11,000 per month, which subsequently has been enhanced to 13,000.
No, that is not there is notification of the state. The question is whether they are entitled to that benefits of that notification.
Since Lordship, we are getting remuneration of 9,000 per month. Still, on the date of filing of this.
So you are not giving 13,000?
No, Lordship, 9,000. Now, kindly see page 25 for once, Lordship, for my satisfaction. The 11,000 subsequently enhanced to 13,750. Got it, Lordship? This is government notification. But still, this day we are getting 9,000.
So in this rate petition, you what you want? 13,700?
Page 38, A, B, C, D, E.
What is your prayer?
My repetition that the representation, pay structure as per Ropa 19 rules. Page 38 also.
Pay structure following ROPA 19.
Lordship.
Whether ROPA applicable to you?
That is
Let
the-
that be considered. Let that be considered.
Yes, that can be considered in time frame.
Let that be.
There is a direction that within time frame we will consider there.
Can you see Lordship page 32 once again? 32. Comment is saying
Your remuneration 8,000.
Lordship. Now it has been 13,000 something. I'm getting 8,000. All the writ petitioners.
Now why you not giving them?
No, they
Page
whether they
25.
will come under this notice because these are all sanctioned casual employees who were appointed through notification post created by the government, but their appointment was not through government, but they were exclusively casual employees on fixed remuneration.
Class to class basis.
Which was time to time enhanced by the government, not on the basis of any notification, but on the basis of their service render. Now their case is that we want the benefits of the government notifications. So that has been placed, whether their nomenclature can be considered under that present this notification, latest notification. So these representatives can be sent to be considered.
Lordship, can you see for once, page 21. Deputy Secretary, Government of West Bengal letter. Second paragraph. After careful consideration, understanding is directed by the order of governor to say that part-time faculties and non-teaching.
Yes, that is a
faculty
dispute.
engaged Polytechnics prior to July 2010, that is weird. Will continue to draw contractual fixed remuneration as defined in the manner of such and such. But still, we are not giving that. This is a government notification. Lordship, analysis, page 22. Page 22. Forwarding of prayers. The prayers were forwarded. Nothing happened. Page 23.
So who is the authority to take the decision?
Lordship,
Technical department.
technical department, Lordship. That is, we have given.
Cost settled.
Director of Technical Education, Training and Skill.
No, respond number. Respond.
Respond number.
Respond 2. 2.
Director of Training, respond number 2.
Respond 2.
Two.
You will consider. He is the authority.
And Lordship, 4 also, because the finance department.
No, close. It will
They
come
will-
subsequent.
They will take decision first. So it's so not required to file affidavit like.
No.
Can we consider?
Yes.
And can you see my note for once, before passing whatever, page 27. In the year 2024, 27/8/2024, the principal in charge Calcutta Polytechnic gave a letter to the Director Department of Technical Education. Can you see the subject? That was also not considered, neither any reply has been given.
No, why it is permission is required, only notification is there.
Lordship, in spite of notifying when we are going, no, we need permission from the
Permission.
director, and we go to director, it says nothing, no response from
Why
his
the
side.
director shall respond?
This is
Already government order is there.
That is the reason we have come before my lord, Lordship.
Okay, please take down. Petitioners are employed. No, প্রথমে লেখো. State respondent was directed by this court to file affidavit in opposition. Full stop. No affidavit in opposition has placed. Having heard the learned counsel appearing on behalf of the state submits that the matter may be relegated to the authority for reasoned decision. Full stop. Petitioners, next paragraph, petitioners were employed as, were engaged as visiting faculty to the post of lecturer and workshop instructor in the Calcutta Polytechnic. What is the name? Calcutta.
Lordship,
Calcutta
Polytechnic
College. Calcutta Polytechnic College. Full stop. It is the case of the petitioner that they are serving under the same post as lecturer and workshop instructor in the same college for more than 10 years.
More than 10 years.
For more than 10 years.
Page 27, Lordship. Page 27. Name, enrolled as, category, date of joining, everything is there. Workshop instructor, electrical engineer, engineering.
Initially, they were remunerated in respect of lecturer, including guest faculty, and workshop instructor engaged on part-time basis.
সেটা ওইটাই তো ডিফারেন্স, ওরা কনসিডার করছে করে যেটা গভর্নমেন্ট স্পন্সর গভর্নমেন্ট তারা পাচ্ছে, এরা পাওয়া গেছে।
While notification dated 31st July 2009, their existing rate of remuneration of ₹100 per lecture period or stroke practical classes be enhanced to 150/100 thereafter void and notification dated 2nd September 2010. Lecturer having AICTE qualifications and taking at least 15 classes per week for rendering over 10 years service was fixed to rupees 15,000 per month. It is the further contention of the petitioner that to a clarification dated 23rd September 2011, Deputy Secretary to the Government of West Bengal has clarified the position regarding part-time appointment of teaching and non-teaching faculty of polytechnics and has categorically opined that বলে এটা তুলবে তো portion. It is the further case of the petitioner that Biden order dated 22nd of July 2024, the government of West Bengal has enhanced the remuneration from 11,000 to 13,750. The petitioner's approach to the principal of Calcutta Polytechnic College for enhancement of their remuneration, but the same was forwarded to the Director, Department of Technical Education and Training for seeking necessary permission. It is the contention of the petitioners that since the government has already taken the decision for enhancement of their part-time remuneration, but they are only given a minimum sum of rupees 8,000 per month. Accordingly, the petitioner has placed a detailed representation to the authority through their learned advocate on 16th of October 2024, which was not considered, hence this writ. Learned counsel for the petitioner submits that the government has already enhanced the remuneration of the present petitioner from 11,000 to 13,750 by V-Day notification dated 22/7/2024. The principal of the Calcutta Polytechnic College has denied the petitioner to the enhanced remuneration and forwarded the matter to the Director Technical Education only to delay the process. He submits that necessary direction may be made so that the present petitioner may be allowed to receive the sufficient remuneration according to the government order. Learned counsel appearing on behalf of the state submits that the concerned college authority has already forwarded the matter to the Director, Department of Technical Education and Training. They have not taken any decision. If the matter is placed, matter be relegated before the authority in a time-bound manner, the grievances of the petitioner may be redressed. Having heard the learned counsel for the parties, also considering the relevant notifications dated 22/7/2024, it appears to me that if the petitioner are come under the zone of the come under the zone of the clarification of Deputy Secretary to the Government of West Bengal by 23rd September 2011, they must have given the sufficient remuneration as per GO dated 22/4/2024, 22/7/2024. However, the instant writ petition is pending before this court, directing the authority to submit a report at this juncture. I think it necessary to relegate the matter before the respondent number 2, before the Director Technical Education, Training and Skill Development Department, Government of West Bengal, being West Bengal Polytechnic branch, being the respondent number 2 of this writ petition, to take a fresh decision in considering the all relevant GOs. Full stop. Under the above observation, the instant writ petition is disposed of, directing the respondent number 2 to consider the representation of the petitioner being annexure P10. Representation of the petitioner dated 16th October 2024, being annexure P10 of the writ petition within 6 weeks from the date of passing of this order, from the date of communication of this order, after giving a reasonable opportunity of being heard to the petitioner. Full stop. The decision of the authorities shall be communicated within 2 weeks from that, within 2 weeks thereafter. Full stop. I make it. This is clarified. Next further, this is clarified that this court has not entered into the merit of this matter. The authority concerned, the respondent number 2 is at leave to consider the representation of the petitioner according to law without being influenced by any observation of this court. Full stop. Since affidavit are not exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted. Disposed of.
Yes. 8,000 to 9,000.
8,000 9,000 plus 1,000.
No, our the petitioner, they are getting 9,000. Page 32. Page 32.
Okay.
10, 11, 12, and 14.
In place of 8,000
to 9,000.
Okay. 9,000.
Good.